Tomorrow.
And fresh matter.
Fresh
matter.
Fresh matter.
Tomorrow.
My lord, MFA fresh matter tomorrow. MFA fresh.
Yes. Yes.
Lord, this is regarding a change of rules of recruitment during the process of the selection. It was heard in the earlier occasion, Lordship. They have changed the rules during the pendency of the.
Coming for admission now. 2022 matter.
ಹೌದು ಇದು 2-3 ಸಾಲಿ ತಮ್ಮ ಮುಂದೆ ಹಿಯರ್ ಆಗಿತ್ತು ಮುಂಚೆ ಅದಾದ್ಮೇಲೆ
The matters to be decided finally.
ಹೌದು
ಆಗೋದಿಲ್ಲ.
ಲೆಟ್ ಇಟ್ ಬಿನ್ ದಿ ಅಡ್ಮಿಷನ್ ನೋಡ್ ಅಂದ್ರೆ ಮತ್ತೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ರೀಚ್ ಆಗಲ್ಲ.
ತಪ್ಪೋದು ಹಂಗ that is not proper. Once we have heard the matter for admission, it cannot be listed for admission again.
It has already been heard. Your Lordship has heard
How
it.
can it be listed for admission?
ಈಗ
List
ಬರೋದೇ
this matter after winter vacation.
Week's time you granted a statement of this file.
So, yes, you are not from sir.
Estimate.
Lord's kindly.
Second matter.
Huh?
Week's time.
24 put 24 or 25 on matter.
Sir, kindly, my lord. I'm
Yes.
sorry for interrupting the course. There is urgency, my lord. Adhyaksha.
Fresh matter.
Fresh matter, my lord.
Fresh
End
matter.
of the list.
Huh?
Adhyaksha, Upadhyaksha, election, my lord. Tomorrow,
Tomorrow. Kodi.
there are fresh matter.
Kodi.
Serial number 33, my lord, I file memo for withdrawal, my lord.
28.
33, my lord.
Oh, sir.
Serial number 33. Learned Counsel for the appellants has filed a memo dated 19/12/2024 seeking leave of this court to withdraw the appeal as not pressed. So, next paragraph. The memo is taken on record subject to all just exceptions. Accordingly, the appeal stands dismissed as withdrawn.
ಸಾರಿ ಮಲಾಡ್ ಮೋಹ ಪೋಸ್ಟಿಂಗ್ ಮಲಾಡ್
Fresh matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
Kodi.
2 days ಕೊಟ್ಟು ಬಂದಿಲ್ಲ ಓನರ್ ಅಪೀಲ್ ಇದೆ ಅಟ್ಯಾಚ್ಮೆಂಟ್
Huh?
ಓನರ್ ಅಪೀಲ್ ಇದೆ
Fresh matter.
ಎಷ್ಟೆಲ್ಲ ನೋಟಿಸ್ ಹೋಗಿದ್ರು
ಹಾ, ಏನಾಗುತ್ತೆ? ನಾಳೆ ಬಂದು ಏನಾಗುತ್ತೆ? ಆಯ್ತು. Yes. ಸರಿ.
week's time you granted my statement objection.
Huh?
I am appealing for behalf of Anand Ture, my lord. Week's time you granted a statement objection.
Matters called out. There is no representation for the appellant. Idira?
ಹೌದು
Huh?
ಹೌದು
At the request of the learned counsel for the respondent. Let this matter after winter vacation.
Appealing, my lordship. Appealing for the appeal. Plaintiff's appeal, my lordship.
Huh?
Suit for declaration of ownership and permanent injunction.
Huh?
And also for damages, my lordship.
Declaration and injunction.
Declaration of ownership,
Huh?
declaration of ownership and injunction and damages, my lordship.
Yes.
It is an plaintiff's appeal, my lordship.
Huh?
Plaintiff is an institution, my lordship, which is running a PU college and a school, my lordship.
You had interim temporary injunction, TI?
My-
Had TI in your favor?
No, my lordship, only in respect of damages, the trial court has decreed in. In respect of damages,
What is your prayer now? Interim
lordship.
prayer?
interim prayer,
Temporary injunction.
not to
For the
alienate,
first time.
not to alienate the suit property, let it be
Focus.
in the same situation, my lordship. While in 2018, the defendant has demolished the shed, my lordship, which the institution was running school and colleges.
Hmm.
In respect of that, I am seeking not to alienate suit property till the disposal of case, my lordship. It is an aided institution which was running from 83 to 4, my lordship.
No, but what is the finding of the trial court?
My lordship,
If you have put up construction on his property,
it is an institution, my lordship. The
ಇರ್ಬೋದಮ್ಮ.
president, my lordship,
no, these who are defendants? They are
they are the son.
They are not part of the institution.
No, my lordship.
Ah,
No,
therefore you have put up some construction on their property.
since from 83 it is running, my lordship. Even the president is the father of the defendant, my lordship.
Huh?
The president was the father of defendant number 2. All of a sudden, he sold the property in favor of defendant number 1. In 2018, in a night, he came and demolished the construction. I am not the party to any proceedings, my lordship. Behind my back, all the.
Huh?
I am the institution, my lordship. Plaintiff is the institution.
Correct. You filed the suit, isn't it?
Yes, my lordship.
Ah. Yes, what do you say?
My lord, she claims herself to be, my lord, the second wife of our father. And in the name of the institution, they want to
The
claim all
suit
this.
is filed
Yes, suit is filed for the
society.
Society.
how she claims, my lord, herself as the president of the society and also claims herself as, my lord, the second wife of our father.
Ah.
Under the name of the institution, she wants to, my lord, enter into this property.
Ah.
The finding of the trial court, neither they have proved the title nor they have proved the possession.
Ah.
My lord, both findings are in our favor, and my lord, when
Construction of the institution has been put up on the property.
that is not been proved.
Since
That
from
that is
83
also, that finding also, my lord, I am filing a crop.
Are you
Because,
also claiming that the society belongs to you, or what is it?
no, I have never said, my lord, society belongs to me.
From 1983, the construction is there.
ಇಲ್ಲ ಅದು ಫೈಂಡಿಂಗ್ ತಪ್ಪಿದೆ, ಅದು ಫೈಂಡಿಂಗ್ ತಪ್ಪಿದೆ ಸ್ವಾಮಿ, because my lord, nothing, the court
My
has
lordship, it
said,
is
the
an
trial court has
adjusted
given
Council,
contradictory view ಕೊಟ್ಟಿದ್ದಾರೆ.
P. Patil has entered appearance for
Not to alienate ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ.
respond number 1. Issue notice to respond number 2. Renuka. Suit was filed by Seema and Yuga Purusha.
Yuga Purusha, he is the present president's father.
Huh?
After the death of Jairaj Chatura, they are the president and secretary of the institution, my lordship.
You cannot show your name. We are only concerned with the society, that's all.
Only in respect of society, my lordship.
Ah. Why do you put the names then?
But they are represented by.
Society represented by its secretary. That's all.
Represented by.
There is no need to mention names also. Why do you mention names like this? Huh? What about Seema?
Seema is the present president, my lordship, and
Huh?
Yuga Purusha- present president of that institution, my lordship.
Seema.
Seema.
ಇಲ್ಲಿ ಯುಗ ಪುರುಷ ಅಂತ ಹಾಕಿದೀರಾ?
And he is the secretary and
ಯುಗ
president.
ಪುರುಷ is the president ಅಂತ ಹಾಕಿದಿರಲ್ಲಮ್ಮ.
Yuga Purusha is the president.
ಹಾ.
ಸೀಮಾ
ನೋಡಿ, when you file this suit,
ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತೇಳಿ ತೋರಿಸ್ತಾರೆ.
Seema is shown as the president.
Yes, my lordship.
Now in your appeal, you have shown Yuga Purusha as the president.
President.
ಯುಗಾಪುರಿ ಆಲ್ಸೋ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ತೋರಿಸ್ತಾರೆ.
Renuka is shown as secretary.
And Seema,
ಇದು ರೇಣುಕ
Yuga Purusha was at that point of time secretary.
secretary.
So now
Now
Yuga
presently
Purusha is the
is
president and
president and
this. so that
Renuka
why
is the
see,
secretary.
You should be careful. When you are filing a suit in the name of the society or a entity, legal entity, all you have to say is suit is filed by so and so, represented by so and so stay. You have to mention the office stay. You don't have to mention the names. And there has to be a resolution.
Resolution.
ಅವೆಲ್ಲ ಏನು ಇಲ್ಲ. Where is the resolution passed by the society to file the suit and the present appeal?
My lordship.
Nothing.
Only in the name of.
These are the basic things you have to follow. When you are filing a suit or a petition in the name of a legal entity, you will have to file a resolution saying by this resolution, it is decided to file this appeal or to file this suit. We have empowered the secretary to file the suit. That is enough. You don't have to show the names because the office bearers may be changing. So every time you need not come and ask for a change of the names in the cost title. It is incorrect.
My lordship, the husband of the appellant.
We are not concerned with that.
I oblige, my lordship.
That is the observation made by the trial court at page number 37. They cannot hold, my lord, two status on that. Page number 37, the court at para 55.
See, the problem is you are also not claiming that this society belongs to you.
No, I am claiming title under my father.
Huh?
We are claiming title
Society.
under. Illa.
It
We are
is a
not
soci-
claiming that
Yeah,
society.
we are talking of this, because the society has established the institution. It has put up construction and the school is running.
School and
But
colleges.
School cannot be run by an individual.
My lord, the
It
school
has
is,
to be run only by a society.
school is being running in, my lord, the separate property, which is also admitted in the cross examination of the plaintiff. They have said they have already running in the institution in the other premises, not this premises. And that is the finding of the trial court.
My lordship, in their written statement, they have themselves admitted that in the
Personal
survey number,
capacity
the
nallo
school and
ಮತ್ತೆ
colleges
institutional
run, my
capacity
lordship.
nallo ಇಬ್ರು
Kindly come to-
ಕೇಳ್ತಾ ಇದಾರಂತೆ. That is the finding of the trial court. Page number 37, my lord, top 3 lines. Therefore, on the capacity of a personal and on the capacity of a president of a
The
plaintiff
defendant
society,
number 2 is claiming.
TW1
that
cannot
he is
hold stands.
the son of ex-wife of Jairaj, my lordship.
ಇದು ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ತಂದು ಸೊಸೈಟಿ ಹೆಸರಲ್ಲಿ ಇದು ಮಾಡ್ತಾರೆ.
And you have not filed any application. You have not filed any application
My lordship,
seeking permission to show the name of these persons instead of what was shown in the
my lordship, it is a,
plaint.
my lordship, the institution is a registered document, my lordship.
Where
which
is the application, madam? How can you go on changing the names in the cost title on your own, is it? There is no need to seek leave of the court.
My lordship,
ಇವೆಲ್ಲ ಪ್ರೊಸೀಜರ್ಸ್ ಫಾಲೋ ಮಾಡ್ಬೇಕಮ್ಮ. Otherwise, on this ground only you will suffer.
Property was standing in the individual name of a father,
Respond number 2.
not in the name of society.
Learned counsel for the first respondent has pointed out the changes made in the cost title when compared to what was shown in the plaint. Stop. It is pointed out that the suit was filed in the name of Janata Pravina Education Society, represented by its president. And the name of the president was shown as Seema, wife of late Jairaj Chature. Full stop. The name of Sri Yuga Purusha was also shown in the cost title as the secretary of the society. Full stop. However, in the present appeal, Yuga Purusha is shown as the president of the society and Renuka, wife of Tara Kant, is shown as the secretary. Full stop. No leave of the court is sought to make such changes. Full stop. Next para. The appellant is required to file necessary application to seek leave of the court to make such changes, if there is a change in the constitution of the office bearers of the society. Full stop. Next para. Nevertheless, we proceed to direct the respondents not to alienate the suit schedule property till the disposal of this appeal. Yes.
CL number 4, Sachin and Mahajan.
Husband's petition. Divorce petition is dismissed.
Huh?
Husband appellant. Divorce
Ah.
petition is dismissed.
Dismissed. Issue notice to the respondent.
CL number 5, to Satyanarayana Acharya.
So wife appeal, my lord. The divorce has been granted. The unfortunate case is that
No
that
delay. No delay,
no delay,
issue notice to the respondent.
sought for interim prayers.
There shall be an ad interim order of stay of the impugned judgment in MC number impugned order in MC number 46 of 2023 on the file of the Principal Judge, Family Court, Raichur, come out till the next date appear.
CL number 6.
Paper the complainant. Nature is the order passed by this honorable court. The directly responded to consider the case of the petition complainant within 6 months. Maladi, that is page 5 of the order page 29. The complainants are guest lecturer Maladi working under these several institutions.
Six months.
Please,
July 2021.
please, Maladi.
The order was passed in July 2021.
2021, Maladi, the complaint.
Beyond the period of 1 year.
Maladi, the complaint filed Maladi in year 2023 itself, Maladi.
Direction issued is to do it within 6 months.
Please. But representation made by the Maladi complainants Maladi on 8/11/2021.
There is a limitation, sir.
Limitation Maladi there. Beyond limitation.
It is beyond limitation.
Please, Maladi.
Yes,
Maladi, recurring cause of action, Maladi, they have not considered the Maladi case. Maladi.
recurring cause of action baralla. If a time period is mentioned, immediately after lapse of that period, your cause of action commence.
Cause of action, Maladi, 6 months, Maladi. 21, Maladi, beyond limitation, Maladi. And one more thing, Maladi, during pendency of the contempt petition, Maladi,
We find that directions were issued by the learned single judge on 27th of July 2021, while disposing of the writ petition, that the respondent authorities shall consider the case of the petitioners for regularization or absorption, within a period of 6 months from the date of receipt of a certified copy of the order. Full stop. Therefore, prima facie, it appears that the contempt petition is filed beyond the period of limitation prescribed. Full stop. Next para. Nevertheless, issue notice to the respondents. Learned government advocate takes notice for respondent number 3. Learned counsel for the complainant is directed to serve a copy of the petition along with annexures on the learned government.
please.
Returnable by notice returnable by 13th of January.
Please.
You want it on
15th, 15th, you will also.
15th Raja
Sorry, 16th.
16th. 16th.
Please.
Please.
14th. ಕಳೆದ ಒಂದು 3-4 ವರ್ಷದಿಂದ
ಸಂಕ್ರಾಂತಿ ಈ ಸರಿ 14.
ಆಯ್ತು
ಕಲರ್ ಬಂದೈತಿ.
ಆಗ್ಲಿ ಬಿಡು ಪರವಾಗಿಲ್ಲ 16th already.
Please.
Non-compliance of office objection for first time, CL number 7, government advocate.
Price of 2 weeks time, my lord.
2 weeks time granted at the request of the learned counsel for learned government advocate for complaints of office objection.
Please.
CL number 8, Arundhati Y.
2 weeks compulsory.
Same order, 2 weeks time.
Non-compliance of office subjection for fourth time, CL number 9, CS Kalaburagi.
Finally, 2 weeks are granted to the appellant for complaints of office objection.
CL number 10, Moga Sudhakar Rao.
Same order.
Non-compliance of office subjection for fifth time, CL number 11.
Weeks
Veeram
accommodation,
Kodapalli.
my lord. Weeks accommodation needful will be done, my lord.
Finally, a week's time is granted. Huh?
Please.
Yes.
CL number 12, additional
At-
government
at-
advocate.
At the request of learned counsel for the appellants.
But this is
Number 12, additional government advocate.
for one week finally, Lord Supreme. 1 week.
Same order. Government advocate.
CL number 13, DP Ambekar.
Finally, 2 weeks.
Order, serial number 14, Veeram Mali Patil.
My lord, in connected matter, lordship have already overruled the office objection and granted stay subject to.
Same order.
Same order. For R1 government, my lord, notice has to go to R1, my lord.
ಅಲ್ಲಿ ಏನಿದೆಯೋ ಅದೇ ತರ.
Please, same, my lord.
Yes.
Please.
Serial number 15, Sangan Baswa B Patil.
My lord, in this case, value of the subject matter is, my lord, below 15 lakh, my lord.
Appropriate bench. Matters to be listed before learned single.
Yes, my lord.
Having regard to the pecuniary jurisdiction, comma, a notice put up by the office that the matter has to be listed before learned single judge. Full stop. Accordingly, this appeal is directed to be listed before the learned single judge.
Good.
Serial number 16, Abdul Muqtadir.
My lords, we have produced the copies as received, my lords, and all the annexures are there in the writ petition copy, my lord.
Huh?
All the copies of the annexure are there in the writ petition copy, my lords. Hence, the same file may be kept below the writ appeal, my lords. The legible copies are not there, my lords, hence we have produced as we have received it, my lords.
Typed copy of document number 2 and 4. Translation copy of annexure sounds legible copy. ಅಲ್ಲಮ್ಮ ಈ ತರದ ಡಾಕ್ಯುಮೆಂಟ್ ನೀವ್ ಹಿಂಗೆ ಹಾಕ್ಬಿಟ್ರೆ ಏನು? You
My
have to
lords, we have
file
received
type-
it. We have received this like that only, my lords.
Maybe.
The same copies are there in the writ petition annexures, my lords.
Huh?
The same are writ petition annexures, my
But
lords.
it's not readable at all.
The copies
You
of,
have to comply. Please file typed copies.
my lords, we are unable to get the certified copies also, my lords.
Certified copy vedama, typed copy. You only have to type it out so that it is legible.
Please, my lords.
Huh?
Please.
Typed copies. The appellant is required to furnish the typed copy of documents number 2 and 4 of IA of additional document. And the annexures in the writ petition. Wherever it is found that the document is not readable, not legible. 2 weeks' time is granted to do the needful.
Obliged.
Serial number 17, Reddy Baswaraj Siddhalingappa.
Lord, appellants are pujaris of the temple in question, hereditary puja. They have been performing the pujas. There is a managing committee, inclusive of appellants also. to manage the affairs of the temple, my lord. This being the position, my lord, it was an ad hoc committee. Later on, it was registered as a registered body, my lord. This being the position, some, my lord, the ill-wishers and antisocial elements of the Tanda, they claimed themselves to be an ad hoc committee and tried to administrate. Thus, there was a dispute between the two factions. As such, police reported to the Tahsildar to initiate 145 proceedings to take possession of the temple's administration. Accordingly, way back in the year 2020, that is 7th January 2020, the administration of the temple was taken by the Tahsildar under section 145.
145 of
Criminal Procedure Code. 145 of the Criminal Procedure Code. And the said proceedings are pending, yet a preliminary order is passed to take the possession. My lord, in that 145, an exhaustive inquiry will be held. Thereafter, whosoever was found to be in possession immediately prior to taking possession by the Tahsildar, it will be handed over to him. If it is not clear, then the Tahsildar will pass an order directing the parties to approach the civil court. That is the procedure under section 145 CRPC.
only regarding possession.
Possession, only regarding possession.
Yes.
That is taken on 7th January 2020. Thereafter, Tahsildar is administering. And we are
That provision does not say anything regarding administering.
no, taking
Yeah, that is-
possession, after taking possession, he had to,
ಎಲ್ಲಿದೆ ಹಂಗಂತ
ಅಲ್ಲ, ಹಂಗಿಲ್ಲ.
ಆತರ ಇಲ್ಲ.
ಈಗ possession ತಗೊಂಡು ಅದನ್ನ,
That is only to ensure that there is no fights in the open.
please, be that as it may. I will leave it.
That's all.
I will leave it.
This
So,
has got nothing to do with the administration.
please, I concede that.
Yes.
So on 7th January 2020, the possession was taken.
Yes.
But the actual administration is being done by the Tahsildar. Of course, my lords are now saying that as per law, it is not.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Be that as it may, the factual aspect is the possession was taken and administration is being run by the Tahsildar since 2020 January. And we being the hereditary pujaris, we were allowed to perform the pujas. For that also a salary is being paid to us by the Tahsildar. This being the position, again at the ill-wishers of the petitioner, Tahsildars with a malified intention on 16th December 2023 passes an order appointing 3 Gram Sahayaks of 3 different villages to perform the puja of the temple.
So
It-
that is.
It is that, I will come to that. It is having
What
some,
is questioned?
it is that, in this it is not questioned, but,
Huh?
it is that which order
Ah.
was questioned by the appellants herein
Ah.
before the learned single judgment.
Ah.
That order. So stay was obtained and we continued to perform the puja.
16/12/2023.
Please, madam.
Annexure G.
ಅಲ್ಲ, ಇದ್ರಲ್ಲೇ annexure,
Annexure G ಅಂತಿದೆ.
ಆಯ್ತು ಸರ್. ಸೊ ಎ ಇರ್ಬೇಕು ಸಾಹೇಬ್ರೆ, annexure
33 page number.
ಎ ಇರ್ಬೇಕು ಸರ್.
ನಿಮ್ಮ prayer ಅಲ್ಲಿ annexure G ಅಂತ ಬಂದಿದೆ, but ಇಲ್ಲಿ annexure A ಇದೆ.
ಹಾ, ಇದೆ. So, my lord, this order
Yes.
This order was challenged by us and obtained the stay. And we continued to perform the puja. The matter had come up for hearing before the learned single judge in the month of November, on 14th November. The state filed the statement of objections. Somehow, our adversaries somehow smelt the matter is being argued and it is being allowed. That is our impression, subject to correction. They, on 16th November, files a writ petition challenging the order of the 16/12/23. In fact, they have no jurisdiction they have no locus to challenge that order. That order was only in respect of performance of puja. 3 gram sahaks are appointed. We are the hereditary pujaris. It is our right, which was curtailed by 16th January 23 by appointing 3 gram sahaks as pujaris. So they challenges the
Writ petition.
writ petition before the learned single judge on 16th of November, and both were taken together. Quite interestingly, they also files an additional order of the same date of the Tahsildar to the effect that some other members are appointed as persons to administer the Adidant, that is A1, which copy was not given to us. Be that as may, as far as that is concerned, we are not learned single judge. Nobody, neither the appellants herein nor the respondent number 2, nobody have questioned 145 proceedings. Learned judge quashes the 145 proceedings. It is that portion of the order which we are impugned. So 2 appeals, my lord. Thereby,
Yes.
so my lord, learned judge allows both the writ petitions, quashes the order under 145. And my lord, what has now happened is, by virtue of this order, see my lord, about the breach of peace, etc., it is the domain of the executive magistrate, and procedure is provided under 145 CRPC. If at all anybody is aggrieved by 145 proceedings, there is another forum, that is under 397 or 399 of the CRPC. A revision has to be filed before the learned session judge. Apart from that, that is a preliminary order. A final order has to be passed by the Tahsildar, which is pending consideration before the Taluk Executive Magistrate. That being so, the respondent number 2 herein, who has no locus to challenge the appointment of pujaris, he files a writ petition, and that is clubbed with mine. And on 27th, learned judge allows both the petitions and quashes 145. As such, I have preferred these 2 appeals, because that 145 portion will be, since it is a common order, that will be my writ petition also, as well as in this writ petition also.
Who is this Ashok who has filed the affidavit?
Ashok is the petitioner,
Not your side?
not my side.
ಹಾ, ನಿಮ್ಗೆ ಇವರು ಹಾಕಿದ್ದಾರೆ ಧರ್ಮರ,
ಅಲ್ಲ,
ಧರ್ಮರಾಜ್,
ಹೌದು,
ನಿಮ್ ಕಡೆಯವರು.
ಹೌದು,
ಹಾ?
ಹೌದು.
Both of them have filed an affidavit.
Yes, yes, yes.
Find that the order is absolutely correct. There is no infirmity in the order.
My lord,
As we said, in paragraph number 11,
please, my lord.
learned single judges said that a perusal of the aforesaid order dated 7/1/2020 purported to have been passed under section 145 of CRPC will indicate that the same is not only contrary to the provisions contained in section 145 of CRPC, but the said order could not have been passed by allegedly taking over the property of the temple or its management, which is not permissible under section 145 of CRPC. In other words, section 145 of CRPC does not permit, enable, authorize the Tahsildar or the state authorities to take over possession or management of the subject temple by invoking the said provision, and consequently, the order dated 7/1/2020 passed by the Tahsildar under section 145 CRPC is clearly illegal, contrary, and without jurisdiction or authority of law, and the same deserves to be quashed. Absolutely correct.
My submission is,
And this arrangement has been made,
ಅಲ್ಲಲ್ಲ, arrangement
Only-
ಮಾಡಿಲ್ಲ.
this arrangement,
No arrangement.
whatever directions are given,
ಅಲ್ಲ, directions.
it is not regarding the archakship. It is only regarding Jatra.
ಹೌದು.
It is which will be conducted in December 2024, January 2025.
Yes.
ಅಷ್ಟೇ.
ಹೌದು.
ಅದ್ ಬಿಟ್ರೆ ಏನು ಇಲ್ಲ.
ಅಲ್ಲ ಸಾಹೇಬ್ರೆ.
You will have to go approach the competent authority or file a civil suit if you have to protect your interest. There is nothing wrong in the order.
ಅಲ್ಲ,
There is nothing wrong in it.
ಅಲ್ಲಲ್ಲ, kindly bear with me.
Yes.
My submission is,
You want to take advantage of the proceedings pending before the Tahsildar from 2020, which is impermissible.
no, I don't
ಮಾಡಕ್
want.
ಬರೋದಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಸ್ವಲ್ಪ.
Sir, if you have to protect your right as archaks, you will have to approach the competent authority
ಅಲ್ಲಲ್ಲ,
or file a suit.
ನನ್ನ ರೈಟ್ಸ್
ಅದ್ಬಿಟ್ರೆ ಇನ್ನೇನು ಇಲ್ಲ.
ಪ್ರೊಟೆಕ್ಟ್ ಆಗಿದಾವ ಸಾಹೇಬ್ರೆ.
Yes.
I have not made myself
No,
clear.
no, no.
ಅಲ್ಲಲ್ಲ,
No, sir.
kindly bear with me.
Yes.
Parame.
Sir, we can't take so much of time for this.
ಅಲ್ಲ,
We can't take so much of time, sir. Yes.
ಅಲ್ಲಲ್ಲ, ಇದರಲ್ಲಿ
ಹಾ.
ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸಾಹೇಬ್, 145 ಆರ್ಡರ್ ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡ್ಲಾರ್ದೆ ಸಾಹೇಬ್.
You filed a petition
ಹಾ.
aggrieved of the fact that the Tahsildar had passed an order in December 2023 naming some persons to conduct the archakship.
ಪೂಜಾ
All that has been set aside now.
ಎಸ್,
Then
ಆಯ್ತು. ಅದ್ರ
what
ಬಗ್ಗೆ
more do you want?
agreed.
If you have to protect your rights, then you will have to approach the competent
ನನ್ನ
authority or
right-
file a suit.
ಅಲ್ಲಲ್ಲ, ನನ್ನ ರೈಟ್ಸ್ ಪ್ರೊಟೆಕ್ಟ್ ಆಗಿದಾವ ಸಾಹೇಬ್.
Not at the hands of the Tahsildar, sir. Under section 145, not possible.
ಅಲ್ರಿ.
You want to take advantage of that, we will not permit it.
I have not made myself clear and I am unable to.
You have understood.
ಅಲ್ಲಲ್ಲ, ತಾವು ನಾನು 145 ಅಡ್ವಾಂಟೇಜ್ ತಗೊಂತೀನಿ ಅಂತ ತಿಳಿದ ಯಾವ ದೃಷ್ಟಿದಾಗ ಹೇಳಕ್ಕೆ
ಹೌದು.
ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ.
See, it's a temporary provision only to enable to see that there is no physical disputes that are happening on the property. That's all. Other than that, there is nothing else in on section 145.
ಅಲ್ಲಲ್ಲ, ಹಂಗಿಲ್ಲ ಸಾಹೇಬ್ರೆ, ಹಂಗಿಲ್ಲ. ತಾವು
That is why the learned single judge has rightly held in paragraph number 11 that all these orders are illegal. It cannot be upheld.
ಸಾಹೇಬ್ರೆ, I require time. ಅದಕ್ಕೆ ತಮ್ಮ ಟೈಮ್ ಇಲ್ಲ ಕಾಣಿಸುತ್ತೆ. It may kind.
No, 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 no. No.
Otherwise, my lord,
Workplace.
my lords may kindly.
Sir, unnecessary dispute should not be brought up.
Unnecessary ಅಲ್ಲ ಸಾಹೇಬ್ರೆ.
So therefore, you approach the competent authority if you want to protect your interest.
ನಾನು ಅಪ್ರೋಚ್ ಆಗೋದ್ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ನಾನು ಅಪ್ರೋಚ್ ಆಗೋದ್ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಈಗ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ತಿಳಿದಂದ್ರೆ ಈಗ my lord, it requires some time. If my lords are not having time, then
No.
otherwise it requires a hearing.
Convinced.
It requires a hearing.
Sir, having regard to the prayer in the writ petitions, both the writ petitions, both of them pertain to section 145.
ಇಲ್ಲ, 145 ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಕತ್ತೀನಿ ಸಾಹೇಬ್ರೆ.
It arises out of the proceedings in 145.
No. 145 ಲಿಂದ ಅರೈಸ್ ಆಗಿಲ್ಲ. ಅದು ನಾನು ಹೇಳಕತ್ತೀನಿ, 145 ಲಿಂದ ಅರೈಸ್ ಆಗಿಲ್ಲ. 145 is not challenged, ಸಾಹೇಬ್ರೆ.
Please see the prayers in the writ petition.
Please.
In WP number 2032228, the challenge is to order dated 16/12/2023.
ಹೌದು
In the other writ petition,
ಅದೇ ಸೇಮ್ ಆರ್ಡ್ರೆ
ಮತ್ತೆ
ಅದು ಅಪಾಯಿಂಟಿಂಗ್
it is passed by the Tahsildar purportedly under section 145.
ನೋ ನೋ ವಿತ್ ಡ್ಯೂ ರೆಸ್ಪೆಕ್ಟ್ ಮೇಲೆ
ಯಾವ provision?
ಅಲ್ಲ 145 ಆರ್ಡರ್ ಇಲ್ಲಿ ಅದ ನೋಡಿ ಸರ್ annexure kindly see that
Making use of the pendency of the proceedings, he has passed this order.
ಯಾರ್
Tahsildar.
ಇಲ್ಲ
Then what is that order?
ಸುಮ್ನೆ ಆರ್ಬಿಟ್ರರಿ ಆಗಿ ಸಾಹೇಬ್ರೆ
From what are the powers exercisable by the Tahsildar? By which power has he passed that order? 6/12/2023.
ಅದು that is one of the ground it is without jurisdiction ಅಂತ
Correct. That is why he has held. He has rightly held. No such jurisdiction is vested with the Tahsildar. He had to conclude the proceedings. Aste, that is only for the purpose of ensuring that there is no physical dispute there. Aste, biಟ್ಟು ಇನ್ನೇನು ಇಲ್ಲ.
ಇಲ್ಲ ಸಾಹೇಬ್ರೆ ಇಲ್ಲ ದಯವಿಟ್ಟು ಇಲ್ಲಿ ಕೇಳಿ it is
You also challenge that order.
which order ಮೇಲೆ
6/12/2023.
ಹೌದು
It has been set aside.
ಸಾಹೇಬ್ರೆ 6/12/23 is regarding performing pujas possession ತಗೊಂಡದ್ದು ಬೇರೆ ಅದ ಸಾಹೇಬ್ರೆ ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ breach of peace ಆಗತ್ತೆ ಸಾಹೇಬ್ರೆ
Government advocate takes notice for respondent number 1. Having heard the learned counsel for the appellant, we find that the order passed by the learned single judge is without any infirmity.
ಅಲ್ಲ ಬೇಕಿದ್ರ ರಿಕಾರ್ಡ್ಸ್ ತರಿಸಿ ತಹಸೀಲ್ದಾರ್ ಕೇಳಿರ್ತಾವ ಅದ್ರಾಗ
We proceed to consider the appeal and dispose of the same without issuance of notice to the other respondents. Next para.
ಅಲ್ಲ ಅದು ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್
The appellants herein filed writ petition number 2032228 of 2024.
ಅಲ್ಲ ನಾವ್ ಹಾಕಿಲ್ಲ ಅದು
ಇದು 203531
ನಮ್ದು ಬೇರೆ ಅದ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಹಾಕಿವಿ ಸರ್ ಅದಕ್ಕೆ
203531
ಹೌದು ನಮ್ದು
203531 of 2023.
ಅಲ್ಲ ಈಗ ಇನ್ನೊಂದು ತಾವು ಸಾಹೇಬ್ರೆ ಅಲ್ಲ ಸಾಹೇಬ್ರೆ
ಅದು ಇದೆಯಾ?
ಹೌದು
ಎರಡು
ಎರಡು ಇದೆ ಅದಕ್ಕೆ ಸಾಹೇಬ್ರೆ
ಅದ್ಯಾರ್ದು?
ಅಲ್ಲ ಅದನ್ನ
serial
ನಾವು
number.
ಹಾಕಿದ್ವಿ.
ಅದು ನೀವೇ ಹಾಕಿದ್ದೀರಾ? ಎರಡು ಅಪೀಲ್.
ಹೌದು ಯಾಕಂತಂದ್ರೆ ಅಲ್ಲ ಒಂದು ತಾವು ಇನ್ನೊಂದು ಪಾಯಿಂಟ್ ತಾವು ಕೇಳಿ
19.
ಅಲ್ಲ ಮೈಲಾಡ್
ಸೊ ಎರಡು ಬರ್ಕೊಳ್ಳಿ.
ಅಲ್ಲಲ್ಲ ಇನ್ನೊಂದು ಪಾಯಿಂಟ್ ತಾವು ಕೇಳಿದ್ರ ನೀವು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ರಿ ನನ್ನ ಒಂದು ಮಾತು ಕೇಳಿ ನೀವು ಮಾಡ್ರಿ
ಹೇಳಿ.
ಈಗ ಅದ್ರ ಬಗ್ಗೆ ಕೇಳಿ ತಾವು ಮಾಡ್ರಿ
ಹೇಳಿ.
ಈಗ as I said under 145 proceedings and my lords under section 145 proceedings after passing a preliminary order there has to be a detailed inquiry. Thereafter an order has to be passed by the Tahsildar. No such neither inquiry nor order is passed and the proceedings are pending. This is one aspect of it. Without there being then arbitrarily he passes an order ಗ್ರಾಮ ಸಹಾಯಕರಿಗೆ ಪೂಜಾರಿ ಅಂತ ಹೇಳಿದ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾರೆ ಅದ್ರ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ಅವ್ರು ಇಲ್ಲಿ ಇನ್ನೊಂದೇನಾಯ್ತು ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು ನಾವು ಅವ್ರು 1 ವರ್ಷ ಆದ್ಮೇಲೆ ದಿಸ್ ವಾಸ್ ಪಾಸ್ಡ್ ಆನ್ 16th December 23 ಅವ್ರು November 14th ಅವ್ರು ರಿಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು ನಮ್ದೆಲ್ಲ ಇದು ನೋಡಿ ಅವ್ರು ಏನಂತ ಮಾಡಿದ್ದಾರೆ ಗೊತ್ತೇನು ಸಾಹೇಬ್ರೆ ಅಶೋಕನ್ ಅವ್ರು ಮಾಡಿದ್ದು ದೇ ಕ್ಲೇಮ್ ಟು ಬಿ ಎ ಕಮಿಟಿ ಆಫ್ ದ ಟೆಂಪಲ್ they wish to administer they were administering ಅಂತ ಹೇಳಿ ಅವ್ರು ಮಾಡಿ ಈಗ rightly or wrongly now the order of the now the single judge has passed 145 proceedings by virtue of this order the petitioners in the other writ petition a seal has been put by this honorable court stating that theirs is the managing committee.
Ellide?
Adu petition, please. Petition is
in the order. Where has the learned single judge said anything? regarding the right of archakship, please show.
ಅರ್ಚಕಶಿಪ್ ಅಲ್ಲ ಸಾಹೇಬ್ರೆ,
ಮತ್ತೆ
ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಬಗ್ಗೆ ಸರ್.
administration ಆಗ್ಲಿ ಅರ್ಚಕಶಿಪ್ ಏನಾರು
ಅಲ್ಲಲ್ಲ,
please show.
ಅಲ್ಲಲ್ಲ, ಐ ಹ್ಯಾವ್ ನಾಟ್ ಮೇಡ್.
Sir, you are required to approach a competent authority or file a suit. Other than that, you cannot do anything. You cannot,
ಅಲ್ಲ ಸಾಹೇಬ್ರೆ,
you cannot proceed only on the basis of the pendency of the.
ಒಂದ್ ಸೆಕೆಂಡ್ ಸಾಹೇಬ್ರೆ, ಈಗ ಅದರ್ ಸೈಡ್ ನವ್ರು ಏನಂತ, ವಾಟ್ ಇಸ್ ದೇರ್ ಲೋಕಸ್?
Both of you,
ಅಲ್ಲ ಸಾಹೇಬ್ರೆ,
whoever is aggrieved have to approach the competent authority or a file a suit.
ಕೈಂಡ್ಲಿ ಅಪ್ರಿಶಿಯೇಟ್ ದಿಸ್ ಆಸ್ಪೆಕ್ಟ್. ಅವರು ನಾವು ಮ್ಯಾನೇಜಿಂಗ್ ಕಮಿಟಿ ಅಂತ ಹೇಳಿ ಈ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಯಾರ, ಇದು ರಿಟ್ ಅಲೋ ಆಯ್ತು ಅಂತ ತಿಳಿದಂದ್ರ ಅವ್ರದೇ ಮ್ಯಾನೇಜಿಂಗ್ ಕಮಿಟಿ ಅಂತ ತಿಳಿದಂತ ತಿಳ್ಕೊಂಡು ದೇ ವಿಲ್ ಸ್ಟಾರ್ಟ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್.
Nothing has been said in the order by the learned single.
ಈಗ ಐ ವಿಲ್ ಶೋ ದ ಆರ್ಡರ್ ಆಫ್ ಗಿವಿಂಗ್ ಹ್ಯಾಂಡಿಂಗ್ ಓವರ್ ಚಾರ್ಜ್ ಟು ದ ಅದರ್ ಸೈಡ್.
Therefore, you will have to question it in a manner known to law, not in this proceedings under 145.
ಯಾವ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು ನಾನು? ಯಾವ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು?
You have to protect your right by approaching the competent authority, sir. If you are saying, I am the administrator, I am the person who is in charge, I am the archak, whatever rights you want to claim, whatever declaration what you claim, you please claim.
That has to be decided by the Tahsildar first.
No, not under 145. It is only regarding possession. Please read. Barkale.
ಅಲ್ಲ ಸಾಹೇಬ್ರೆ, ಈಗ
No, sir. Enough, sir.
ಎರಡು ಕಾಮನ್ ಆರ್ಡರ್.
Yes, yes.
ಯಾಕಂದ್ರೆ ಆ ಒಂದು ಪಾಯಿಂಟ್ ನು ತಾವು ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ. ಬಿಕಾಸ್ ವಿ ಇಂಟೆಂಟ್
Order dated 16.
ಕನ್ಸಿಡರ್ಡ್ ಆರ್ಡರ್. ಯಾಕಂದ್ರೆ ದೇರ್ ಇಸ್ ಎ
passed by the respondent Tahsildar. Appointing three Grama Sevaks to perform, to ensure that the puja and the other activities in the temple known as Sri Mariamma Devasthana, situated at Kalakora Tanda, Basava Kalyan, is maintained in order. Full stop. Subsequently, the contesting respondents also filed another writ petition in WP number 2032228 of 2024.
ಅವ್ರ ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲ ಸಾಹೇಬ್ರೆ ನಮ್ಮ ಹತ್ರ. ಅವ್ರು ನಮ್ಮ ಹತ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲ. ಅವ್ರ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ ನಾವು.
ನೀವು ಇವಾಗ ಅಪೀಲ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದಿರಲ್ಲ ಇಲ್ಲಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್. Again challenging the same order dated 16/12/2023. Full stop. The learned single judge, after considering the contentions of both the rival claimants, held as follows anta ಮಾಡಿ paragraph number 11, 12 ಎರಡು extract ಮಾಡ್ತೀನಿ. Next para. Having regard to the provisions contained in section 145 of CRPC, we are of the considered opinion that the learned single judge is absolutely right in holding that the impugned order dated 16/12/2023 could not have been passed by the Tahsildar by virtue of the pendency of the proceedings initiated under section 145 of CRPC, which is meant only for the purpose of ensuring that physical disputes do not happen regarding land or water. Full stop. Therefore, the provision is only to enable the magistrate to decide as to who was in possession of the property immediately before the proceedings were initiated, and appropriate orders in that regard is permitted to be passed by the Tahsildar, declaring such party to be entitled to possession thereof until evicted therefrom in due course of law, and forbidding all disturbances of such possession until such eviction. Full stop. The Tahsildar is also entitled to pass orders to restore possession in favor of a party forcibly and wrongfully dispossessed. Full stop. Other than this, there is no other power vested in the Tahsildar, either in respect of the administration or management of the temple. Full stop. That being the position, we are of the considered opinion that no infirmity can be found in the impugned order. Stop. Next para. Further, certain directions have been given by the learned single judge having regard to the admitted fact that a jatra is to be conducted in the temple during the month of December 2024-January 2025. Full stop. In that regard, the affidavits of both the parties, representatives of both the parties have been taken, and the same has been called out in paragraph number 14 and 15 of the impugned order. Full stop. Accordingly, while setting aside the orders dated 7/1/2020 and 16/12/2023 passed by the Tahsildar, who had invoked section 145 of the CRPC, appropriate directions have been given by the learned single judge to comply with and abide by the undertakings given by the respective parties, representatives of the parties, to ensure that no law and order problem would be caused during the jatra to be conducted in the month of December 2025 to January December 2024 to January 2025. Bracketally wrongly typed as December 2025 to January 2026. Close bracket. Full stop. We therefore do not see any infirmity which would require any interference at the hands of this court. Full stop. Next para. Since certain apprehensions were expressed by the learned counsel for the appellant that the contesting respondents will take advantage of the impugned order, we make it clear that the learned single judge has said nothing regarding the rights of administration, management or archakship of the temple. Full stop. Any aggrieved party is required to approach the competent authority or a civil court to get declaration of his rights in respect of the administration, management or archakship of the temple. Full stop. The writ petition is accordingly, the writ appeals are accordingly dismissed.
Allah, one the observation.
If you are aggrieved, sir. If you are not aggrieved, don't go.
Allah, I am aggrieved.
I said, if you are aggrieved, you'll have to approach the
ಅದ್ರ
competent.
ಬಗ್ಗೆ ಆಯ್ತು ಸಾಹೇಬ್ರೆ ಇಲ್ಲಿ ಕೇಳಿ ಇಲ್ಲಿ ತಾವು ದಯವಿಟ್ಟು ಯಾಕಂದ್ರೆ ನನ್ನ ಪ್ರಕಾರ ಅದು ಅಬ್ಸರ್ವೇಷನ್
ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
ಈಗ ಅದರ್ ಸೈಡ್ ನವ್ರು ಫೈಲ್ ಮಾಡಿರೋದು ರಿಟ್ಟು ಕ್ಲೇಮಿಂಗ್ ಟು ಬಿ ದಟ್
ಹೋಗಿದೆಯಲ್ಲ, ಎರಡು ತೆಗ್ದಾಕಿದ್ದಾರೆ. They were also challenging the order dated 16/12/2023 only.
ಅಂತಂದ್ರೆ ಅವ್ರು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ನಾವ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಮಾಡಾಕತ್ತೀವಿ ಅಂತ ತಿಳಿದು ಮಾಡಾಕತ್ತಾರ ಅಂತ ಹೇಳಿ
ಎಲ್ಲಿದ್ದಾರೆ ಸರ್?
ಅವ್ರ repetition-
there is no such order. Therefore,
ಅಲ್ಲಲ್ಲ ಈಗ ಒಂದ್ ಪ್ರಶ್ನೆ ಐ ಪುಟ್ ದ ಕ್ವಶನ್ ಟು ಮೈಸೆಲ್ಫ್.
yes,
ಈಗ 145 ದಾಗ ತಹಸೀಲ್ದಾರ್ ಯಾರಿಗಾನ ಒಬ್ರಿಗೆ ಕ್ವಶನ್ ಕೊಡ್ಬೇಕ? ಆತ ಅಂತರ ಏನು ಮಾಡಿಲ್ಲ. ಈಗ ನೀವನ ಕೊಡ್ರಿ, ಯಾರಿಗ್ ಕೊಡ್ತೀರಿ? ಸಿಂಗಲ್ ಜಡ್ಜ್ ಕೊಟ್ಟಾನ ಯಾರಿಗಾನ? ಸಿಂಪ್ಲಿ 145 ಕ್ವಾಶ್ ಅಂತ ಮಾಡಿಬಿಟ್ರಿ.
there is no physical dispute now.
ಅದೇ
Arrangement has been made to ensure that the jatra will be proceeded.
ಜಾತ್ರೆ ಬಗ್ಗೆ ಆಯ್ತು.
So
What
therefore,
about the possession which is taken by the ತಹಸೀಲ್ದಾರ್ is the question.
ಏನ್ ಪೊಸಿಷನ್ ತಗೊಳಕ್ ಬರದೇ ಇಲ್ಲ ಸರ್ ಅದ್ರಲ್ಲಿ.
ತಗೊಂಡ್ ಬಿಟ್ಟಾನಲ್ಲ, ರೈಟ್ಲಿ ಆರ್ ರಾಂಗ್ಲಿ. ನೀವ್ ಯಾರಿಗಾನ ಕೊಡ್ರಿ, ಈಗ ನನಗಾನ ಕೊಡ್ರಿ, ಅವ್ರಿಗಾನ ಕೊಡ್ರಿ ಅಂತ
No,
guarantee ಬರಲ್ಲ.
no. There is absolutely no need to say that. Yes.
ಯಾಕಂದ್ರೆ 145 ದಾಗ ತಗೊಂಡ್ ಬಿಟ್ಟಾನ.
No, no, no.
ಆಯ್ತು ಆಯ್ತು.
Let's say appear for
ಎರಡು ಬೋತ್ ಕಾಮನ್.
Both
Bill number
yes.
18, my lord, I appear for the
senior
appellant in this matter.
ಹೇಳಿದ್ನಲ್ಲ,
let's say
ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಟೇಕ್ಸ್ ನೋಟಿಸ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1, ಮಿಕ್ಕಿದ್ ನಾಟ್ ನೆಸರಿ ಅಂತಾನು ಹೇಳಿದ್ವಿ. ಸೇಮ್ ಆರ್ಡರ್,
I appear for the appellant.
ಕಾಮನ್ ಆರ್ಡರ್. Yes,
Let's say appear for the appellant, senior appellant.
Bill number 18, my lord, I am appearing in this matter.
yes.
As a matter of fact, my lord, in a connected matter, your lordship has already stayed the order of the learned single judge. 20028. I'll request my learned friend to hand over.
ಸಾಕಿದ್ದು ಮತ್ತೆ ಸೀನಿಯರ್ ಹಾಕ್ಬೇಕಿತ್ತು ಅದಕ್ಕೆ.
Allah, really, this, because my lord,
When order
only
is already
reason was-
passed, the similar orders will pass.
Delay the 8
Same,
days.
same order as in
8 days delay.
bill number 200-283 of 2024.
the only reason, my lord, I'm appearing is only because some statements have been made against Bharat Petroleum and its officials. That's the only reason.
Allah, there is already an order passed.
There is an order passed, my lord.
8 days
Same
delay
order.
this one.
Huh?
8 days delayed filing writ appeal.
The question of delay, condonation of delay of 8 days in filing the appeal will be considered after the respondents appear before this.
Great.
Yes.
Blessed.
Bill number 20, Sanjay Kulkarni. Bill number 2020. Furnishing of PO.
2 weeks' time is granted to the appellant to take steps for service of notice on the respondent.
Bill number 21, Ulepa Erur.
Yes,
I am producing suspension orders in respect of present petitioner. 2 suspension order in same year. my lord.
Yesterday's order, Lord has, yesterday's matter,
ah,
Lord is directed to produce. He has suspended, he has produced the documents which are already on record.
that other
Yes,
officer,
ma'am.
They are already on record.
suspension,
No, appellant
For
is
that he is producing
suspended.
today.
appellant already,
My lord,
that other lady,
my lord, reasons I am mentioning. He has suspended in January 20.
Putri,
Nine,
see the directions issued by the tribunal.
yes, my lord.
Asking you what happened, what steps? Learned additional government advocate is directed to secure instructions as to why the co-delinquent employee Srimati Uma Devi Sonnad has not been placed in suspension.
The departmental inquiry is pending.
ಇವ್ರದ್ದು ಅಷ್ಟೇ.
Yes, my lord, because
Why have you not suspended that other lady?
my lord.
Huh?
My lord, I inquired with,
Similar charges
Yes.
are being considered against the petitioner
my lord,
and that other lady. Why only he is kept under suspension? And you give charge to that lady.
my lord, because he has earlier also he has misappropriation of funds.
Barkal.
My lord,
May I request your lordship? May I request your lords?
By order dated 12/12/2024, we had directed the learned government advocate to secure instructions as to why the co-delinquent employee dash Srimati Umadevi Sonnad has not been placed in suspension, when similar allegations and charges are leveled against her and she is permitted to work.
Yes. She is functioning.
However, after giving two opportunities, no information is forthcoming as to why no action is taken by the competent authority to place the co-delinquent officer also under suspension, if she is facing similar charges. Full stop. Next para. In fact, in the order passed by the Karnataka State Administrative Tribunal, Elri Adu,
Annexurium.
May I request you, Lordship, 2:30, my lord, I'll get the information, I'll make submission, my lord. I thought that, my lord, he received the instruction from the department. But insufficient, my lord, instruction is received by him, my lord. I'll take instruction, I'll make submission 2:30, my lord.
no, let us. Elri Adu, where is that?
Page number 45,
35,
44, 5.
45. Elli 45 ಅಲ್ಲಿ. There was such a direction given by the tribunal also.
Yes.
As to why that lady has not been kept into suspension and why she is she has been given charge when she is also facing similar.
Why not on Swami? Why they continued in the same post ante, there is observation. That is only, my lord, not suspending. But kindly see, that is, my lord. That earlier order is not produced, my lord.
We saw that.
Previous writ petition he
Directions
produced, my lord.
issued.
Previous writ petition, my lord. He filed it before Lordship, my lord. In that, my lord, that order was produced.
Page number
But kindly
120.
see, 129, my lord, for a moment. He produced that copy of the order, my lord. 129. Under these circumstances, it is just necessary to direct the respondent authorities to make necessary arrangement to take additional charges of the post of the.
Page number 129.
Yes. Facing similar charges that of the appellant.
Yes. In fact, the Karnataka State Administrative Tribunal Sorry, 2 and 4 herein. For partition and separate possession. And at any rate, the matters have to be decided on merits. Full stop. Accordingly, we condone the delay while allowing the application. Full stop. Next para.
Stay, yeah, please.
Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned counsel for respondents number 1 and 2. Next para. The trial court is directed not to drop the final decree
Aforesaid.
without express orders of this court. Yes.
Number 29, GG chart. Appearing for the complainant, my lordship.
Yes.
My lordship, in this dispensation of production of a certified copy of Annex A, my lordship. They have not implemented a single learned single judge order, my lordship. The salary of
Annexure
97.
A? What is annexure A?
My lordship, it is an order passed by the,
In contempt petition, what are you producing?
the learned single judge has passed an order for granting 97 to 2008 salary of the petitioner, my lordship. Even though there is an order by the
Passed on 6th of August 2024.
24, within 2 months, my lordship.
Huh?
There is a duration of 2 months, my lordship.
Why are you putting this annexure A?
My lordship,
For what?
that they have rejected my claim, my lordship.
2011 the document ido. Why are you producing it in the contempt petition?
My lordship, I have produced a representation by with the judgment, my lordship, as per Annexure C, my lordship.
Huh?
As per Annexure C, I have made an application with the,
Sorry, why are you producing annexure A?
by giving this, they have rejecting my salary, my lordship, by producing this.
2011 document amma idu annexure A.
Kindly pass on, my lordship, I'll just verify.
You take back this document.
My lordship,
See,
Yes.
we are to consider whether the respondents who are directed to consider your case and pass orders have complied with the directions or not.
that's
Where is
one.
the requirement to see annexure A? We are not going into the merits of the matter. Learned counsel for the complainant submits that annexure A was not required to be produced in this contempt petition. And therefore, the complainant may be permitted to remove annexure A from the petition. Full stop. Leave is accordingly granted. Full stop. Learned next para. Learned government advocate takes notice for respondent number 3. Learned counsel for the complainant is directed to serve copy of the appeal, a copy of the petition along with annexures on the learned government advocate. Next para. Issue notice to response number 1 and 2 returnable by 16th of January.
Number 30.
I appear for the complainant minutes. I filed a dispensation of an IA for dispensation of production of Annexure C minutes. Certified copy of, I have filed IA for dispensation of production of a certified copy of Annexure C minute.
What is annexure C?
Order of this division bench order minute.
Huh?
Page number 32. Certified copy of Annexure C minutes. Ink page 32.
This is your order under which directions have been given?
Yes, minutes.
Huh?
Yes, minutes.
Then you will have to furnish certified copy.
Meanwhile, sir,
Huh?
I filed IA for dispensation.
Dispensational ray, you should say. You should say.
I'll file.
Grant us some more time.
Please.
This this procedure of filing an application for dispensation is incorrect.
Please. 2 weeks time, my lord.
Say, I'm asking for extension of time.
Please.
Dispensation ಅಂದ್ರೆ ಅರ್ಥ ಏನು? Huh?
I'll file.
ಅಲ್ವಾ?
Yes, please.
All of you are doing this same mistake.
I'll file.
You are filing applications for dispensation of production of certificate copy. It cannot be dispensed with.
I'm sorry, I'll file.
The requirement of law is that if you are challenging an order, certificate copy have to be produced.
Please.
Or if you want the court to look into a certain order for which you say there is no complaints, certificate copy is required to be produced.
Obvious.
You can't seek dispensation.
Obvious. I'll file.
Order on IA number 1 of 2024. This application is filed by the complainant seeking 4 weeks time for production of the certificate copy of annexure C. Full stop. Accordingly, 4 weeks time is granted.
Obvious.
Complainant to furnish the certificate copy.
Please.
IA number 1 of 2024 is accordingly disposed of.
My lord, I am seeking.
Issue notice to the respondents. Returnable by 16th of January.
Obvious.
Number 31.
There is, this says there is objection with, my lord, with regard to the translation copy, my lord, I have filed a dispensation, Kannada language, annexures. And my lord, there is a delay of 65 days in filing this appeal, my lord. My lord, sir, the order, my lord, passed by the learned single judge is a 4/9/2024, my lord. Lord, the second respondent had issued amalgamation order to the appellant, my lord, at first instance on 16/5/2022.
Who had filed the writ petition?
Yes, brother.
Ah.
My lord, challenging the learned single judge's order, my lord.
Huh? What did you seek in the petition?
Petition, my lord, amalgamation order was issued by the second respondent at first instance. Since 3 portions of land were purchased by the appellant from previous landowner, he made an application for the second respondent for amalgamation of the 3 portion into 1 portion.
Commissioner of Kalaburagi Urban Development Authority.
Yes, brother.
Ah.
At first instance, my lord, the amalgamation order was issued.
Ah.
My adjacent owner had made a complaint to the second respondent that I have the right to weigh through my plots, my lord. The second respondent entertained the complaint at first instance, my lord, revoked temporarily. For first, thereafter, my lord, I had given an undertaking to an effect that before the second respondent that for once for all for solving the problem, I gave the undertaking that in my building, I will leave 10 into 6 feet, 10.6 feet space to the adjacent owner. Taking
building your plot.
Yes, bro. Thereafter, my lord, considering my affidavit, the second respondent, temporary revoke order has been recalled. Thereafter, once again, my lord, the adjacent owner filed a suit for.
What is the interim prayer? There is no interim prayer.
Yes, there is interim prayer. My only question before this honorable court is, once the amalgamation order is passed, whether the second respondent can.
What is the interim prayer? Is
Yes,
there any interim prayer?
Yes,
matter is coming up for what now?
Not delay is there, my lord.
Delay.
Yes.
ಆದ್ಮೇಲೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕಷ್ಟೇ. ಇನ್ನೇನ್
ಏನಾಗಿದೆ ಈಗ
ವಾಟ್ ಇಸ್ ದಿ ಇಂಟ್ರಿಮ್
yes annexure yes stay I have sought annexure yes my lord stay I have sought my lord ninth my lord since my lord in view of the revocation of amalgamation order the corporation has
stay ಮಾಡಿದ್ರೆ you will proceed.
yes my lord
Not permitted.
I will take notice my lord.
Learned government advocate takes notice for respondent number 1. Learned counsel Sri Kripasagar Patil is requested to take notice for response number 2 and 3.
Two my lord Tengli Mr. Tengli GDA for Urban Development Authority Shivkumar Tengli and 3 Kripasagar.
ಇಲ್ಲಿ ಬರೀ ಕೃಪಾಸಾಗರ್ ತೋರಿಸಿದ್ದಾರೆ.
ಅಲ್ಲಿ
single jet order.
Let it go. Yes, I will take.
He only appeared for both the authorities.
Yes, but it was in preliminary hearing itself and my lords they had passed the order since the earlier order.
He appears for both the authorities.
No, my lord, I think for GDA, my lord, Gulbarga Development Authority will not appear.
Kripasagar Patil, Gulbarga Urban Development Authority.
ಇಲ್ಲ ಅವರು ಅಪೇರ್ ಆಗಂಗಿಲ್ಲ ಸುಮ್ಮನೆ ಇದು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಒಳಗೆ ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತು ಅಲ್ಲಿ. Anand Jagirdar for second respondent.
Learned counsel Sri Anand Jagirdar is requested to take notice for respondent number
2. 3 Kripasagar.
2. And learned counsel Sri Kripasagar Patil is requested to take notice for respondent number 3.
There is a delay, my lord.
Full stop. Learned counsel Sri B. Noor Ilyas is requested to take notice for respondent number 4.
I will serve.
Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned government advocate as well as the other learned counsels. Yes.
Seal number 32, Sudarshan.
On liability, Lord, there were 2 vehicles involved in the accident. Head-on collision, my lord, and the other vehicle, my lord, driver not holding a driving license.
So there is a delay. Learned counsel for the appellant insurance company submits interim ad interim order.
Please, much.
Notice to all the respondents.
All respondents.
Yes.
Much.
Seal number 34, Sandeep Vijay Kumar.
Matters called out. There is no representation for the appellant. Issue notice to the respondent.
Seal number 35, Ricky Patil.
On IA number 1 of 2024.
Ricky Patil Melkundi.
This was comes from
34 days delay. Insurance company. Previous year the same.
much.
36, Kausalya Chit.
Manavendra Reddy is requested to take this for point number 2. Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on learned counsel for respond number 2. Next per issue notice to respond number 1. Oh, you're owner of the vehicle. Your claimants. I'll respond number 1 will be the owner of the vehicle. issue notice to respond verbatim.
Seal number 37, Prashant B. Ujantri.
Madam, for the petitioner, madam.
Yes.
Lord, the petitioner while working as senior motor vehicle inspector, my lord. Lord, he entered into an altercation with the MLA, my lord, while checking the vehicles. Lord, based on that, my lord, he was transferred to, sent on deputation outside the mischief area to Raichur, my lord.
Enter into.
Altercation with the local MLA, my lord, while checking the vehicles. Thereafter, my lord, based on that incident, my lord, he was shifted from Bidar to Raichur, my lord, outside the mischief area. Subsequently, my lord, on a letter communicated through the director of Karnataka Legislative Assembly, my lord, he has been placed under suspension, though he is outside the mischief area. My lord, I placed before the material before the tribunal, my lord, stating that since he is working outside the mischief area, question of placing him under suspension doesn't arise, as he is not likely to tamper with any records. That is the reason assigned. But ignoring that, my lord, merely on the ground that there is a letter from the Legislative Assembly, my lord, they have placed me under suspension, and the impugned order sought to be granted, my lord, it came to be rejected.
Interim order.
Yes, ma'am. Page 13 is the interim order, my lord, that is sought to be rejected. Though I had made out a prima facie case, my lord, because he is working outside the mischief area. Kindly see the impugned order, my lord. They specifically say that I am likely to tamper with the records. Impugned order is at page, order of suspension is page 30, my lord, relevant portion. Page 27 is the order portion. Page 30, my lord. ಸದರಿ ದಾಖಲೆಗಳಿಂದ ಸರ್ಕಾರ ನೌಕರರು ಅನುಚಿತ ವರ್ತನೆ ತೋರಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಅವರ ವಿರುದ್ಧ ಆರೋಪಗಳ ಬಗ್ಗೆ ಸುಗಮ ತನಿಖೆ ಅಡ್ಡಿ ಉಂಟು ಮಾಡುವ ಅಥವಾ ತನಿಖೆಯಲ್ಲಿ
information regarding you being sent outside the district.
That is in the same page 28, Mala.
28.
Second paragraph. ದಿನಾಂಕ 30/10/24 ಮಾನ್ಯ ಸರ್ಕಾರ ಸಾರಿಗೆ ಆಯುಕ್ತರು ಬೆಂಗಳೂರು ಅವರು ಅಧಿಕೃತ ಜ್ಞಾಪನ 30/10/24 ಇವರ ಆದೇಶದಿಂದ ಸದರಿ ಅವರು ಕಾರ್ಯನಿರ್ವಹಣೆ ವ್ಯವಸ್ಥೆ ಅಡಿ ಪ್ರಾದೇಶಿಕ ಸಾರಿಗೆ ಅಧಿಕಾರಿ ಕಚೇರಿ ಬೀದರ್ದಿಂದ ಕಚೇರಿ ರಾಯಚೂರು ಇಲ್ಲಿಗೆ ತಕ್ಷಣವೇ ಬಿಡುಗಡೆ ಮಾಡುವಂತೆ ತಿಳಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ದಿನಾಂಕ 30/11/24 ಅಪರಾಹ್ನ ಕಚೇರಿ ಕರ್ತವ್ಯದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಿ ರಾಯಚೂರು ವರದಿ ಮಾಡಿಕೊಳ್ಳಲು ಸದರಿ ಅವರು ಮಂಜುನಾಥ್ ಕೊರ್ವಿ ಅವರಿಗೆ ದೂರವಾಣಿ ಕರೆ ಹಾಗೂ ವಾಟ್ಸ್ಆಪ್ ಸಂದೇಶ ಮೂಲಕ ಸೂಚಿಸಲಾಯಿತು. He has already reported there. Now, my lord, on the ground that he is would tamper with the records, my lord, he is being placed under suspension.
Learned government advocate takes notice for all the respondents. Learned counsel for the petitioner is directed to serve copies of the report along with annexures on the learned government advocate. Top next paragraph. Learned counsel for the petitioner submits that by order dated (30/10/2024) passed by the third respondent,
Second respondent.
Second respondent, Commissioner.
Yes.
Of the Department of Transport and Road Safety, the petitioner was transferred from Bidar to Raichur, and accordingly, on 30/11/2024, the petitioner took charge at Raichur. Full stop. Nevertheless, after the petitioner took charge at Raichur, and for the alleged misconduct which happened during his posting at Bidar, the impugned order of suspension is passed on 4/12/2024 on the ground that the petitioner will tamper with the records. Full stop. Learned counsel submits that despite making out a prima facie case, the Karnataka State Administrative Tribunal declined to consider the interim prayer for stay while holding that the applicant has not made out a prima facie case. Full stop. The petitioner is therefore before this court being aggrieved of the tribunal not passing an interim order of stay. Full stop. Next para. Having regard to the facts stated herein above, and on perusing the impugned order dated 4/12/2024, we find that in the impugned order itself, these facts have been narrated. In page number 2, stop. It is clearly stated that an order was passed on 30/10/2024, transferring the petitioner from Bidar to Raichur on the ground of the alleged misconduct, which happened at Bidar. Full stop. Long after the petitioner took charge at Raichur and has been working at Raichur from 30/11/2024, the impugned order was passed on 4/12/2024, placing the petitioner under suspension on the ground that he would tamper with the records. Full stop. Learned counsel for the petitioner has made out a prima facie case for grant of interim relief. Stop. Accordingly, we proceed to pass an interim order of stay of the impugned order dated 4/12/2024 at annexure A2, till the next date of hearing before the tribunal. Full stop. Next para. The writ petition is also accordingly disposed of, while directing that the interim order passed by this court shall be maintained until any other express order is passed by the tribunal. Yes.
I am for the petitioner, Lord.
Yes.
As per annexure A2, Lord will find page number 21. This petitioner has been put on deputation for a period of 1 year, that is 2024 and 25. Lord will find my name at item number 12 on page number 22. And
Serial number?
Serial number 12, my lord. Serial number 12 reflected on page number 22.
Srimati Savita Patil.
Yes.
Saha Shikshaki, Sarkari Hiya Prathak Shale, Kalaburagi, Vijaypura Jille, sent on deputation to
Sarkari Hiriya Prathamika Shale.
Nagara, Vijaypura Jille.
Yes.
In the same city.
1 year, only for 1 year.
In the same city.
Deputation.
In the same city.
Same city.
ಅಲ್ಲ ಸಾಲ
ಇದು city ಬೇರೆ, ಇದು.
ಸಾಲವಡಗಿ.
Yes, ma'am. It is district place.
ಹಾ
Salavadigi,
ಹಾ
Lord, it is a place in the Bijapur district, Bijapur Taluka.
ಡಿಫರೆಂಟ್ ತಾಲೂಕಾ ಇಸ್ ಇಟ್?
No, Bijapur Taluka only.
ಬಿಜಾಪುರ ತಾಲೂಕಾ.
She is coming from a rural area to city.
ಹಾ ಹಾ
I may permitted to read page number 21. While the government has passed the order, page number 21, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಈ ಕೆಳಕಂಡ ಶಾಲಾ ಶಿಕ್ಷಕರುಗಳನ್ನು 2024-25ನೇ ಸಾಲಿನ ಅಂತ್ಯದವರೆಗೆ ಅವರ ಹೆಸರಿನ ಮುಂದೆ ಸೂಚಿಸಲಾದ ಸ್ಥಳಕ್ಕೆ ನಿಯೋಜಿಸಲು ನಿಯೋಜನೆ ಮುಂದುವರಿಸಲು ಸರ್ಕಾರವು ಅನುಮತಿಸಿದೆ ಎಂದು ತಮಗೆ ತಿಳಿಸಲು ಪ್ರೆಸಿಡೆಂಟ್.
So therefore, there itself they have made it clear that it will be only till the end of 2025. Yes.
That is not my grievance. For 1 year. Lord will see next year A3. The commissioner, that is second respondent, issues direction to the DDPIs to comply the order. Lord will find at page number 25.
90 ಜನ ಸರ್ಕಾರಿ ಪ್ರಾಥಮಿಕ ಶಾಲಾ ಸಹ ಶಿಕ್ಷಕರನ್ನು 2024-25ನೇ ಸಾಲಿನ ಶಿಕ್ಷಣ ವರ್ಷದ ಅಂತ್ಯದವರೆಗೆ ನಿಯೋಜನೆ ಮುಂದುವರಿಸಲು ಅನುಮತಿ ನೀಡಲಾಗಿರುತ್ತದೆ. ಪ್ರಯುಕ್ತ ಸರ್ಕಾರದ ನಿರ್ದೇಶನದಂತೆ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಅಗತ್ಯ ಕ್ರಮ ವಹಿಸಲು ಸೂಚಿಸಿದೆ.
Yes, ma'am. To comply the direction issued as per annexure A2 to page number A3. In pursuance of this, Lord will see annexure A4 page number 26. DDPI issues movement order, followed by Lord BO direct the headmaster to allow this petitioner to join duty. As per that, Lord, she has been relieved and she joins duty on 14/8/2024. Lord will find joining report annexure A5, page number 31.
Page number
31. 32 typed copy. And the headmaster acknowledges. Thereafter, Lord, annexure A6 came to be issued on 28/10/24, saying that BO Muddibihal writes to BO Vijaypura, saying that the petitioner should be sent back to her original place, as there is a direction from the higher authorities. My Lord will permit me to read. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀಮತಿ ಸೋಂಡ್ಸೋ ಸಹ ಶಿಕ್ಷಕರು ಸರ್ಕಾರಿ ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ಸಾಲವಾಡಗಿ ಮದ್ದಬಿಹಾಳ್ ವಿಜಯಪುರ ಇವರು ಸರ್ಕಾರಿ ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ನಂಬರ್ 16 ಆದರ್ಶ ನಗರ ವಿಜಯಪುರ ನಗರ ಇಲ್ಲಿ ನಿಯೋಜನೆ ಮೇಲೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾರೆ. ಆದರೆ ಉಲ್ಲೇಖಿತ ಆದೇಶದಲ್ಲಿ ಮಾನ್ಯ ಆಯುಕ್ತರು ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಬೆಂಗಳೂರು ಇವರು ಸದರಿ ಶಿಕ್ಷಕರನ್ನು ಪ್ರಸ್ತುತ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಮೂಲ ಶಾಲೆಯಲ್ಲಿಯೇ ಕೂಡಲೇ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಲು ಸೂಚಿಸಿದ್ದಾರೆ. ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಮಾನ್ಯ ಉಪನಿರ್ದೇಶಕರು ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆ ವಿಜಯಪುರ ಇವರು ಮಾನ್ಯ ಆಯುಕ್ತರ ಪತ್ರದನ್ವಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿದ ಪ್ರಯುಕ್ತ ಸದರಿ ಶಿಕ್ಷಕರನ್ನು ನಿಯೋಜಿತ ಶಾಲೆಯಿಂದ ಬಿಡುಗಡೆ ಮಾಡಲು ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿದೆ. This is on 28/10, within 2 months. Followed by Lord, the BO directs to the headmaster to relieve the petitioner from his school. Accordingly, she has been relieved on 29/10/2024 as per annexure A8. My Lord will find page number 35. Agreed by this, she makes a representation to the DDPI Bijapur requesting, since I am deputed, I have shifted my family, admitted my children, all her grievances she has put forth in annexure A9, page number 37. This DDPI only he has come to know only after my representation. Till then he did not know what has transpired between BOs. My Lord will find annexure A10, page number 39. He writes to the BO to place the material before him. What has made him to relieve her and retransfer her to original school? My Lord may permit me to read. Page number 39, annexure A10. May I read? Page number 39, my Lord, annexure A10. DDPI writes to the concerned BO as to how he has relieved her. May I read, Lord? ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ಶ್ರೀಮತಿ ಸೋಣಸೋ ಶಿಕ್ಷಕಿ ಸರ್ಕಾರಿ ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ಬಾಲಸಾವಡಿಗೆ ಮುದ್ದಬಿಹಾಳ್ ನನ್ನು 24-25ನೇ ಅಂತ್ಯದವರೆಗೆ ಸರ್ಕಾರಿ ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ನಂಬರ್ 16 ವಿಜಯಪುರ ಇಲ್ಲಿಗೆ ನಿಯೋಜಿಸಿ ಆದೇಶಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಮಾನ್ಯ ಅಪರ ಆಯುಕ್ತರು ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಧಾರವಾಡ ಸದರಿ ನಿಯೋಜನೆಗೆ ಚಾಲನೆ ಆದೇಶ ನೀಡಿರುತ್ತಾರೆ. ಪ್ರಯುಕ್ತ ಉಲ್ಲೇಖ 3ರ ಈ ಕಚೇರಿಯ ಪತ್ರದಲ್ಲಿ ಶಿಕ್ಷಕರನ್ನು ಬಿಡುಗಡೆ ಹಾಜರಾತಿ ಕ್ರಮ ವಹಿಸಲು ಸಂಬಂಧಿಸಿದ ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿಗಳಿಗೆ ಸೂಚಿಸಿರುತ್ತಾರೆ. ಅದರಂತೆ ಅವರು ಮೂಲ ಶಾಲೆಯಿಂದ ಬಿಡುಗಡೆ ಹೊಂದಿ ನಿಯೋಜಿತ ಶಾಲೆಗೆ ಹಾಜರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದು, ಈಗ ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ಸದರಿ ಶಿಕ್ಷಕರು ಈ ಕಚೇರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಅವರನ್ನು ನಿಯೋಜನೆಯಿಂದ ಯಾವುದೇ ಕಾರಣ ನೀಡದೆ ಬಿಡುಗಡೆಗೊಳಿಸಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿ, ಸರ್ಕಾರದ ಹಂತದಲ್ಲಿ ಸದರಿ ನಿಯೋಜನೆಯು ಶೈಕ್ಷಣಿಕ ವರ್ಷದ ಅಂತ್ಯದವರೆಗೆ ಚಾಲ್ತಿಯಲ್ಲಿ ಇರುವುದರಿಂದ ಅವರನ್ನು ನಿಯೋಜಿತ ಶಾಲೆಯಲ್ಲಿ ಮುಂದುವರಿಸಲು ಕೋರಿ ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಶೈಕ್ಷಣಿಕ ವರ್ಷದ ಮಧ್ಯದಲ್ಲಿ ಶ್ರೀಮತಿ ಸುವರ್ಣಿಸೋ ಸಹ ಶಿಕ್ಷಕರು ಇವರ ನಿಯೋಜನೆ ನಿಗದಿಪಡಿಸಿದ ಇಲಾಖೆ ಆದೇಶ ಅಥವಾ ನಿರ್ದೇಶನಗಳಿದ್ದಲ್ಲಿ ಮಿಲಾಡ್ ಆದೇಶ ಅಥವಾ ನಿರ್ದೇಶನಗಳಿದ್ದಲ್ಲಿ ಈ ಕುರಿತು ನೀವು ಕೈಗೊಂಡಿರುವ ಕ್ರಮದ ಬಗ್ಗೆ ನಿಖರವಾದ ದಾಖಲೆಗಳೊಂದಿಗೆ ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿದರು. He is asking, place the material before me. What are all transferred in pending state? I am agreed by this approached KAT.
Who is the competent authority to issue a transfer order?
DDPR.
DDPA.
DDPR. This as a special case government has issued this time. Annexure A2.
Where is it?
What?
ಯಾವುದು?
ಸರ್ಕಾರ ಆದೇಶ ಮಾಡಿದೆ ಡೆಪ್ಯುಟೇಷನ್ A2. Allowed will find annexure 21, page number 21, annexure A2. This is issued by government.
ಹೆಂಗ್ರಿ ಮಾಡ್ತಾರೆ ಇದೆಲ್ಲ? See, the transfer of teachers can be done only through counseling, isn't it?
Yes, ma'am, that is true.
Then how?
This is my lord, only deputation. It is only deputation, my lord.
Aದೇನ್ರಿ deputation ಅಂದ್ರೆ we fail to understand.
That is the some confusion. Lien
You can simply use the term deputation instead of transfer. Is that the meaning? You have pointed out to that definition of the word
Yes, in other case.
deputation in that other matter.
Yes.
Deputation would arise only when the person is being sent from one department to another.
Yes. Please.
There cannot be a deputation
Within
the same department.
Lien ಆಗುತ್ತೆ.
ಮತ್ತೆ for your convenience, suiting your convenience, you simply use the word deputation. When the transfer of teachers is protected by way of counseling only, how all these things are done?
I'll get instruction, my lord. Annexure R6 ಅಲ್ಲಿ ಉಲ್ಲೇಖದಲ್ಲಿ 2ದಲ್ಲಿ ಡೆಪ್ಟಿ ಡೈರೆಕ್ಟರ್, my lord, ಡೆಪ್ಟಿ DDPI only
Also asking, ಎಲ್ಲಿದೆ ಯಾವ information, who passed that order, you please show it to me ಅಂತ.
ಅಲ್ಲ DDPI ಅವರದ್ದು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಸರ್. Annexure R6
in page number 39 is asking the block education officer, which is that order ಆದೇಶ ಅಥವಾ ನಿರ್ದೇಶನಗಳು ಇದ್ದಲ್ಲಿ ಈ ಕುರಿತು ನೀವು ಕೈಗೊಂಡಿರುವ ಕ್ರಮದ ಬಗ್ಗೆ ವಿವರವಾದ ದಾಖಲೆಯೊಂದಿಗೆ ಈ ಕಚೇರಿಗೆ ವರದಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿದೆ.
ಕರೆಕ್ಟ್. ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 22 my lord. ಉಲ್ಲೇಖ 2ರಲ್ಲಿ
ಅದೇ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ ಅದರಲ್ಲಿ.
29 ಅಂತ ಏನ್ ಆರ್ಡರ್ ಅಂತ ಅದು ನೋಡು. ದಟ್ ಆರ್ಡರ್ ಇಸ್ my lord 29/2020. ದಟ್ ಇಸ್ ಉಲ್ಲೇಖದಲ್ಲಿ ಹೇಳಿದ್ದು.
ಪೇಜ್
ಬಟ್ ಪೇಜ್ ನಂಬರ್ 22 ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಉಲ್ಲೇಖ 2
22 ನ.
Yes, my lord. Page number 22. Oh, sorry, 33 my lord. 33. ಬೇರೆ 2 ಹಾಕಿದ್ದಾರೆ. Annexure A6 ಉಲ್ಲೇಖ 1 ಮಾನ್ಯ ಆಯುಕ್ತರು ಶಾಲಾ ಶಿಕ್ಷಕ ಬೆಂಗಳೂರು ಇವರ ಆದೇಶ ಶಿಸ್ತು. This one ಉಲ್ಲೇಖ 2ರಲ್ಲಿ DDPI ಆರ್ಡರ್. These 2 orders, my lord, if we see, my lord, that is, my lord, it will be clear. That order is not produced.
Now the DDPI himself is asking.
ಅದೇ ಈ ಆರ್ಡರ್ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್. ಉಲ್ಲೇಖದಲ್ಲಿ ಇದೆ. ಅವ್ರು ಹಾಕಿಲ್ಲ, ಬೇಕಾದ್ರೆ ನಾ ತರಿಸ್ತೇನೆ. I'll get this order.
Already DDPI is asking.
ಅದೇ
ಯಾವ್ದ್ರಿ ಆರ್ಡರ್ ಅಂದ್ಬಿಟ್ಟು ಅದು.
ಅದೇ 29.
He himself has passed that order. Where the question of him asking, which is that document?
That's why, my lord, why, my lord, he refer that, that in ಉಲ್ಲೇಖದಲ್ಲಿ, my lord, that 20th 9 ಅಂತಾನೆ refer ಮಾಡ್ತಾರೆ. This is, my lord, on the basis of the order of the
Also
commission.
on interim prayers.
Yes.
Learned government advocate takes notice for all the respondents. Learned counsel for petitioner is directed to serve copy of the writ petition along with annexures of the learned government advocate. Full stop. Next para. The petitioner is aggrieved of the fact that the Karnataka State Administrative Tribunal
Annexure B, page number 40.
has declined to pass interim orders on the application filed by the petitioner. Full stop. Next para. Learned counsel for the petitioner submits that annexure A2 is the order passed by the state government, through the undersecretary, Department of
Education.
Primary Education. Full stop. Annexure A2 is an order dated 26/7/2024, whereby 38 school teachers were deputed to the post shown therein. Until completion of the academic year 2024-25. Full stop. Accordingly, the petitioner took charge at the deputed post.
A5, page number 31.
Government Higher Primary School, Adarsh Nagar, Vijayapura on
14/8.
14/8/2024. Full stop. However, the block education officer, Mudde Bihala, appears to have made a communication dated 28/10/2024 at annexure A6 to the block education officer Vijayapura, urban division, stating that the commissioner, Department of Education and the Deputy Director,
Yes, DDP Vijapur.
Deputy Director of Public Instructions have made a communication directing that the petitioner should be sent back to her previous place, that is Government Higher Primary School, B. Salavadagi, And accordingly, the block education officer, Vijaypura, urban division passed the impugned order on 29/10/2024, relieving the petitioner from Adarsh Nagar, Vijaypura, with the direction to
Directing the headmaster to relieve
directing the headmaster to relieve the
petitioner.
To enable the petitioner to go back to her previous place, that is B. Salavadaki.
Yes.
Full stop.
Headmaster release on annexure A8.
But the petitioner approached the DDPI, Vijaypura, and the DDPI made a written communication dated 7/11/2024 at annexure A10 to the block education officer, Vijaypura, calling for the information which formed the ground on which the petitioner was asked to be relieved. Full stop. It is pointed out that the DDPI has expressed surprise on the fact that he himself did not know of such an order being passed by the commissioner. And without bringing all these aspects to his notice, the block education officer has passed the impugned order. Full stop. Next para. Having regard to the facts narrated herein above, and on perusing the petition papers, this court is of the consistent opinion that the petitioner has made out a prima facie case for grant of interim relief. Full stop. Next para. Accordingly, there shall be an ad interim order of stay.
Annexure A6 to 8.
Of the impugned order dated 20/10/2024 and 29/10/2024 at annexure A6 to A8, till the next date of hearing. Next para. The writ petition is accordingly disposed of, while directing that the interim relief granted by this court shall continue until any express order is passed by the tribunal after the appearance of the respondents.
Correct.
Seal number 39, Mahesh Patil.
I am also, my lord, here, my lord, on consideration of an interim order.
Huh?
My lord, I am also, my lord, here, my lord, non-consideration of an interim order.
You know?
My lord, my interim, my lord, order has not been considered by the tribunal.
Interim order.
Same.
My
lord, here, my lord, the petitioner, my lord, is working as, my lord, Panchayat Development Officer. My lord, Panchayat Development Officer. My lord, there was an, my lord, on a complaint, my lord, by the president of the very same Panchayat, my lord, an inquiry, my lord, was caused by the, my lord, the EO of the Taluk Panchayat. My lord, he formed, my lord, 3-member, my lord, committee, my lord, to inquire into those charges. My lord, the committee, my lord, they submitted their report, my lord, at page 103, annexure A8. Page 103, annexure A8. My lord, on each count of the charges, my lord, the findings were given. My lord, at the last, my lord, in page 103, last, ಸಮಗ್ರ ವೆಚ್ಚದಲ್ಲಿ ದಿನಾಂಕವನ್ನು ಪಾವತಿಸಲಾಗಿರುತ್ತದೆ. ಅಂಡ್ ಅದೇ ರೀತಿ 104 ಅಲ್ಲಿ in each count of charges, my lord, it was, my lord, found, my lord, that, my lord, there is no, my lord, discrepancy, my lord, and my lord, that everything is in order. And my lord, hence, my lord, neither of these, my lord, the allegations made by the president are true. That was the findings, my lord, by each, my lord, count. Enroll ಆಗಿರೋದು ಕಂಡು ಬರುತ್ತದೆ, ಪ್ರತಿ ಲಗತ್ತಿಸಿದೆ, ಇವನ್ ಅಲಾಂಗ್ ವಿತ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಮೂದಿಸಿ ನಂತರ ಬಳಕೆ ಮಾಡಿರುತ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್, ಅನುದಾನ ಈಗಾಗಲೇ ಪಾವತಿಸಿರುವುದಾಗಿ ದಾಖಲಾತಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅದಾದ್ಮೇಲೆ ಅದರಿಂದ ಈ ಸಾಮಗ್ರಿಗಳನ್ನು ಗ್ರಾಮ ಪಂಚಾಯತಿಯಿಂದ ಯಾವುದೇ ಅನುದಾನ ಪಾವತಿಸಿರುವುದಿಲ್ಲ. ಅದಾದ್ಮೇಲೆ ಪಂಚಾಯತಿಯಿಂದ ಯಾವುದೇ ಅನುದಾನ ಪಾವತಿಸಿರುವುದಿಲ್ಲ. Likewise, my lord, in each on each count of the charges, my lord, the 3-member committee, my lord, had submitted their report.
What is the conclusion?
My lord, conclusion, my lord, in each para itself, my lord, they had, my lord, made it clear along with the documents saying as to.
It is only recording the submission made by you. So they had to give a finding.
ಇಲ್ಲ ಇದು ಫೈಂಡಿಂಗ್ ಇದೆ ಕೊಟ್ಟಿದ್ದಾರೆ. This is the report. This is the report.
So we don't find any conclusion arrived at.
Yes, my lord. May I take, my lord, forward,
All right.
kindly. My lord, thereafter, my lord, the CEO, my lord, being not satisfied, my lord, he, my lord, orders one more, my lord, oral inquiry. Oral inquiry, my lord, to be conducted, my lord, Chief Accounts Officer. That is at page 117. Page 117. The lordship may kindly see, my lord, at page 117. My lord, here Maukika Adesha Dinaka 31/8/2024. He had, my lord, ordered by, my lord, direction by other mele report ಕೊಟ್ಟಿದ್ದಾರೆ. The Chief Accounts Officer, my lord, he submits a report. Now, my lord, this report, the finding, my lord, is at page 126. 126. ಅದರಲ್ಲಿ ಲೆಕ್ಕ ತನಿಖೆ ವರದಿಯಲ್ಲಿ ಕಂಡು ಬಂದ ಲೋಪದೋಷಗಳಿಂದ ಸಂಬಂಧಿಸಿದ ಆಕ್ಷೇಪಣೆ ಮತ್ತು ವಸೂಲಾತಿಗಾಗಿ ಸೂಚಿಸಿದ ಮೊತ್ತದ ವಿವರ. ಮೆನ್ರೇಗಾ ಮತ್ತು 15 ಹಣಕಾಸು ಯೋಜನೆಯಲ್ಲಿ ನಿರ್ವಹಿಸಲಾದ ಕಾಮಗಾರಿ ಕೂಲಿ ಮತ್ತು ಪಾವತಿ ಹಾಗೂ ಸಾಮಗ್ರಿ ಖರೀದಿ ಬಿಲ್ಗಳನ್ನು ಲೆಕ್ಕ ಪರಿಶೋಧನೆ ಕೈಗೊಳ್ಳಲಾಗಿ ಸದರಿ ಲೆಕ್ಕ ಪರಿಶೋಧನೆಯಲ್ಲಿ ಕೆಳಕಾಣಿಸಿದಂತೆ ಆಕ್ಷೇಪಿತ ಮತ್ತು ವಸೂಲಾತಿ ಮೊತ್ತವನ್ನು ಸೂಚಿಸಲಾಗಿದ್ದು ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಹಾಗೂ ಮಾರ್ಗದರ್ಶನ ಪ್ರಕಾರ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದಾಗಿರುತ್ತದೆ. This is the, my lord, the finding of the, my lord, the Chief Accounts Officer. Now, my lord, the course, my lord, now based on this, my lord, lordship may kindly see, my lord, at page, the suspension order, my lord, has been issued, my lord, which is at page page 109. Page 109, my lord, the relevant portion, my lord, 1110 second para. My lord, 110 second para. May I read? Shrimati Purnima alias Ratnamma, Panchayat Abhivruddhi Adhikari, Gram Panchayat RH Camp, Taluka Sidnuri ಅವರು ಈವರೆಗೂ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ವಿವರಣೆಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಇದರಿಂದ ಸದರಿ ಅವರು ಸದರಿ ಅವಧಿಯಲ್ಲಿ ದಿನಾಂಕ ರಲ್ಲಿ ರೂಪಾಯಿ ಸೋನ್ಸುಗಳನ್ನು ಸರ್ಕಾರದ ಹಣ ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಳ್ಳುವುದು ಮುಖ್ಯ ಕಾರ್ಮಿಕ ಅಧಿಕಾರಿಗಳು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ರಾಯಚೂರು ಅವರು ನೀಡಿದ ವರದಿಯಲ್ಲಿ ಕಂಡು ಬರುತ್ತದೆ. ಕಾರಣ ಶ್ರೀಮತಿ ಪೂರ್ಣಿಮಾ ಅಲಿಯಾಸ್ ಸೋನ್ಸು ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ HR ಕ್ಯಾಂಪ್ ತಾಲೂಕಾ ಸಿಂಧೂರು ಇವರು ಸರ್ಕಾರದ ಹಣವನ್ನು ದುರುಪಯೋಗ ಮಾಡಿಕೊಳ್ಳುವುದು ಮತ್ತು ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಸೋನ್ಸು. My lord, here, my lord, now in the suspension order, my lord, it is alleged, my lord, that my lord, there is a misappropriation of funds.
Yes.
My lord, here, my lord, in neither of the report, my lord, conducted by the 3-member committee, nor by the report of the, my lord, Chief Accounts Officer, my lord, there is no, my lord, alleged misappropriation, my lord, against, my lord, the petitioner whatsoever. Now, my lord, the suspension order, my lord, has been issued, my lord, on the based on the, my lord, that, my lord, there has been misappropriation of amount. There is no prima facie. Now, even before these two inquiries were caused, my lord, there was a statutory audit, my lord, which was conducted, which in the normal course, my lord, they do. My lord, that is at page 35. Even, my lord, in the normal course, my lord, which the audit, my lord, was conducted, my lord, there was no, my lord, irregularities or, my lord, misappropriation, my lord, which was, my lord, pointed out in the normal audit. Now, my lord, lordship may, my lord, kindly, my lord, see, my lord, once again, my lord, the report, my lord, at the cost of repetition, my lord, here, the report of the Chief Accounts Officer, my lord, at page 126. May I, my lord, once again, my lord, page 126. ಅದರಲ್ಲಿ ಲೆಕ್ಕ ಪರಿಶೋಧನೆ ಕೈಗೊಳಿಸಿದ್ರಿ. ಲೆಕ್ಕ ಪರಿಶೋಧನೆಯಲ್ಲಿ ಕೆಳಕಾಣಿಸಿದ ಆಕ್ಷೇಪಿತ ಮತ್ತು ವಸೂಲಾತಿ ಮೊತ್ತವನ್ನು ಸೂಚಿಸಲಾಗಿದ್ದು ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಹಾಗೂ ಮಾರ್ಗದರ್ಶನ ಪ್ರಕಾರ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದಾಗಿರುತ್ತದೆ. ಮಲೋಡ್ ಹಿಯರ್ ಮಲೋಡ್ ಆಕ್ಷೇಪಿತ ಮೊತ್ತ ಆಮೇಲೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಮಲೋಡ್ ದೇರ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿಫ್ರೆನ್ಶಿಯೇಷನ್ ಬಿಟ್ವೀನ್ ಮಲೋಡ್ ದಿ ಆಕ್ಷೇಪಿತ ಮೊತ್ತ ಮತ್ತೆ ಮಿಸ್ಅಪ್ರೋಪ್ರಿಯೇಷನ್. ನಾವು ಮಲೋಡ್ ದಿ ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ರಾಜ್ ಆಕ್ಟ್ ಮಲೋಡ್ ಸ್ಟಿಪ್ಯುಲೇಟ್ಸ್ ಮಲೋಡ್ ದಿ ಪ್ರೊಸೀಜರ್ ಮಲೋಡ್ as to when such certain objection amount in such cases as to how it has to be proceeded. That is section 246 subsection 6 of the Panchayat Raj Act. So 246 6. Married. On receipt of the audit report, the Gram Panchayat shall either remedy any defects or irregularities which have been pointed out in the report and send to the executive officer within 3 months. An intimation of its having done so, or shall within the same period furnish to the executive officer any further explanation in regard to such defects or irregularities. 7. On receipt of such intimation or explanation in respect of all or any of the matters discussed in the audit report, the executive officer may, in consultation with the editor, accept the intimation or explanation given by the Gram Panchayat and order the withdrawal of the objection, or direct that the matter be reinvestigated at the next audit or at any earlier date, or direct that the defects or irregularities pointed out in the audit report or any of them shall be removed or remedied by the Gram Panchayat. So, this is the procedure which has been prescribed.
If audit objection is raised.
Idre. And in the case on hand, there is no finding prima facie with regard to any misappropriation of funds. Now the suspension order has been issued stating that there is misappropriation. The 10(3) of the CCA rules stipulates
Sir, you should not be permitted to continue in the same post. Not possible.
Here, Lordship may kindly see, the very president, where I'm working in the Gram Panchayat, he himself is competent to the sign, all those things. He himself makes allegation against the PDO.
Who has made allegation?
The president himself, the president of the very Gram Panchayat himself, he makes allegations, and these inquiries are prima facie made, and it is found that there is no material whatsoever. And now, insofar as the suspension order is concerned, if there are some objections, some amount it could have been remedied as
more than 68 lakhs, there is a difference.
There is no misappropriation as such. It is
whether you call it misappropriation or a defect. An amount of 68 lakhs which is required to be found in the account is missing.
If that is so, let there be, let them.
The very idea of placing an officer under suspension is to ensure that he will have no access to the records.
I do agree, I do agree. But the 10(3) stipulates that there should be examination of the materials before passing suspension order. And that such reflection should be there in the suspension order itself. Now the very suspension order says that is
government advocate takes notice for response number 1. Notice to response number 2 and 3. Learned counsel for the petitioner is directed to serve copy of the petition along with annexures on the learned government advocate. Yes.
May I seek some immediate after vacation someday?
You are before the tribunal anyway. You go and argue the matter before the tribunal. Yes.
Number 40, Muhammad Abdul Kaim.
Time for the caveatum. My appeal is also there pending.
It's an appeal by insurance company.
Huh?
Accident involves two vehicles. Auto rickshaw was negligent, but liability is fixed on the parked lorry. So on negligence and quantum, this appeal is filed. I am filing memo to dispense with notice to R2 and R3.
Learned Counsel Sri Sanjeev Patil has entered appearance for respondent number 1. Learned Counsel for the appellant insurance company has filed a memo seeking dispensation of notice. Response number 2 and 3 on the ground that
Liability. is not
There are two instances, my lordship.
they are the owners.
They are the owners of the two vehicles, one lorry and auto rickshaw. 2 and 3 are the owners of the lorry and auto rickshaw. They challenge only contribute negligence,
Quantum.
contributed negligence,
Negligence and quantum.
contributed, but it is his vehicle is parked vehicle.
Huh?
His lorry is parked vehicle, my lordship, in the middle of the road, state highway. On that ground, my lordship,
You are the claimant, isn't it?
I am the claimant, my
You
lordship.
are the claimant.
Claimant. It is a case of amputation, my lordship.
So there were two vehicles.
Two vehicles. One auto rickshaw and one lorry.
Both the drivers were charge sheeted.
But the
Liability is fixed only on lorry.
only on one vehicle.
Only on God, that is a parked vehicle, in the middle of the road. At 6:30 PM,
Evening time.
evening.
And response number 2 and 3 are the owners of the two vehicles involved in the accident. And the liability has been fastened on the appellant insurance company. And the appellant insurance company is only on the question of contributory negligence, for which the other vehicle has been insured by respondent number 4.
Respond.
For Mr. M. Sudarshan.
At the risk of the appellant, notice to response number 2 and 3 is dispensed with. Next para.
There is a delay of 35 days.
Which are generally? Huh? Yaar advocate?
M. Sudarshan. M. Sudarshan.
Mr. Sudarshan. Learned Counsel Sri M. Sudarshan, who is present in the court, takes notice for respondent number 4. Learned Counsel for the appellant is directed to serve copy of the appeal memo along with the annexures on
Delay of 35.
the learned counsel for respondent number 4.
Delay of 35 days may kindly be condoned.
ಅದು ಮಿಕ್ಕಿದ್ದು ಸೇಮ್ ಆರ್ಡರ್ ನಾವು ಮಾಡಿದ್ದೀವಿ. Although there is delay, we have passed interim orders, add interim orders, 50% bit deposit.
My lordship, I am permitted to withdraw, my lordship, 50% amount. It is a case of amputation. Contributed negligence 21 lakhs ಇದೆ.
Next para. Liberty is also reserved to the claimant to seek release of the amount deposited by the insurance company before the tribunal.
Collect this, my appeal is offered.
Appeal.
Appeal is none appeal.
List this matter along with MFA 203607 of 2024.
Seal number 41, Preeti Patil Milko.
I may be permitted to represent Preeti, madam. This is also appeal by insurance company questioning liability for an unauthorized passenger. 5 days delay is there. Stay may kindly be granted.
Issue notice to both respondents, to all the respondents.
All the respondents. Yeah.
Make it the same order. Delay, although there is delay of 5 days, make it the same.
Stay is
Yes.
Seal number 42, Sandhan Basu B Patil.
Appeal, my lord. My lord, ex parte declared diverse challenge before this honorable court, my lord. Delay in filing, my lord, 58 days, my lord.
You apprehend that she will get remarried.
Please, my lord. Please, my lord.
Issue notice to the respondent. Next para. In the meanwhile, the respondent is directed not to contact any other marriage during the pendency of this appeal. Yes.
Obviously.
Seal number 43, Anita M. Reddy.
The wife is the appellant, your lordship. And she challenged the judgment and decree passed by the principal family court Raichur in the divorce petition, and that was allowed by the family court on 2016-10-2024. By challenging this appeal preferred, but delay of 15 days is there.
Same order.
And IA one, please.
That will be considered after the appearance of the other side.
No, your lordship, because that decree already passed, please.
You have directed him not to contract any other
Please,
marriage.
please.
Yes.
Cell number 44, final disposal, Sudarshan M.
Your advocate. You feel 44.
44 minutes. May it please your lordship. 44 minutes. Miller's land is acquired for the purpose of laying railway line from Bidar to Gulbarga, Millers. Preliminary notification is of the year 25/11/2010. Final notification is 8/11/2011. ಆಮೇಲೆ ₹1.05 ಪ್ರಕಾರ per square feet ಗೆ ಅಂತ award ಆಗಿತ್ತು 27/8/2013. After reference, my lords, the LAC court has passed at the rate of ₹24 per square feet. Aggrieved by that, we are before your lordship. And 2010 to this day, my lords, we are struggling very hard. And we have lost.
You are seeking further enhancement.
Howd Swami, howd. Your lordship may kindly take, there are 3 appeals now. Your lordship may kindly take MFA 200/843 of 2022. That for reference, your lordship may kindly take, my lords.
Yes.
Your lordship may kindly see, we had given exhibit P29, which is a sale deed of 7/6/2010. Exhibit P29 is a sale deed of 7/6/2010, where 80, if we calculate, it comes to
Records for exhibit
P29, my lords. This date may also be relevant. This is a sale deed of the year 7/6/2010, my lords. ಇದರಲ್ಲಿ ಲೆಕ್ಕ ಹಾಕಿದ್ರೆ ₹80 per square feet ತರ ಆಗುತ್ತೆ ನಾವು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರೆ.
Preliminary notification and date
25/11/2010. PN is 25/11/2010. FN is 8/11/2011. 8/11/2011. Award is passed on 27/8/13. P29, my lords.
29.
This is 1 minute. Exhibit P30 ತಗೊಂಡ್ರೆ ತಾವು. That is of 7/6/2010 again.
Exhibit
P30. P30 30.
ಅದು ಸೇಮ್ ಡೇಟಾ.
ಹೌದು. ಅದು ₹79.37 ಅಂತಿದೆ. ನಾನು ಆವರೇಜ್ ಅಲ್ಲಿ ₹80 ಅಂತ ತಮ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ₹79.37 ಆಗುತ್ತೆ ನಾವೆಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರೆ ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಎಷ್ಟಾಗುತ್ತೆ? ₹9.37 ಆಗುತ್ತೆ. 79.37 per square feet ಬರುತ್ತೆ. ಆಮೇಲೆ ಎಕ್ಸಿಬಿಟ್ P31 ಒಂದು ಕೊಟ್ಟಿದ್ದೀವಿ. This is 30th day of October. 30/10/2009.
2009.
ಅಲ್ಲ 2009 ಸ್ವಾಮಿ 9. ಹೌದು. ಇದು ಮೂರು ನಾನು ನ್ಯಾಯಾಲಯ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಫಾರ್ ದಿ ರೀಸನ್ ದಟ್
ಇದರಲ್ಲಿ ಏನಿದೆ ರೇಟು?
ಇದರಲ್ಲಿ 75,000 rupees ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
75,000 rupees?
ಅದನ್ನ ಲೆಕ್ಕ ಹಾಕಿದ್ರೆ 93 rupees ಬರುತ್ತೆ ನಮ್ಗೆ.
93 rupees
ಬರುತ್ತೆ. ಇದನ್ನ ಕನ್ವರ್ಟ್ ಮಾಡಿದ್ರೆ.
Submission. Don't mind. Other several matters are pending connected with old matters. There are 20 to 30 matters are there. Same village. So there will be.
You are also appearing for railways, huh?
Yes.
No, I see now no more in the panel now.
Panel is,
That is what I've received now.
panel is abolished.
Huh?
As per our notification, panel is abolished.
abolished. I don't know why my learned friend is interfering when the matter is
ಅಲ್ಲ
going
ಆಯ್ತು,
on.
ಇವಾಗ ಈ ಮ್ಯಾಟ್ಲಿ
Means 30 matters I have filed an appeal. It is with me because are pending consideration.
appeal filed on behalf of the railways.
These are pending, subject to do 24 rupees. Don't do, stay motivated. There are 20, 21, 22 matters are there. Some 30 matters are there.
So his contention is railways also have filed an appeal, so both have to be heard together.
Yes.
Not with respect to this
May not
LSC.
be.
Village,
Not
same
be.
village.
But if there are appeals arising from the
Yes.
same
Village.
notification,
Yes.
and the railways also has filed appeals,
Yes.
he is saying hear both of them together,
Lords, there are.
and that is the right way of
Yes.
doing things.
May I just intervene? May I just
ಒಂದ್ಸರಿ ಇಯರ್ ಮಾಡಿ ಆಮೇಲೆ ಅದರ್ ಸೈಡ್ ಇಯರ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
May I just intervene here, Mellors?
Yes.
A minute.
ಹಾ.
Mellors, there have been, in fact, there was another case, Exhibit P32, we had produced before the court. Stating that, I understand. Coming to that question only, I am requesting, Mellors. Whether they have challenged the orders passed in this particular LAC is one thing. If they have filed, definitely yes. Otherwise, what would happen is each portion has to be separately decided by your lordship. In each case, what is the amount each one is entitled, because by and large for all the villagers, same statistics may not be applied. That's one aspect. And assuming for a while, I am not insisting that your lordship should hear it, dispose it today itself. That's up to your lordships. But I am respectfully submitting here. One submission is that assuming for a while this court decides something, then that can be taken as a benchmark if need be, or this portion is far away or here. That's
one, considering the appeal filed by the railways, say if they have filed any other appeal in
Not
respect of the
against this
same
number.
in respect of the same village,
Yes.
then what should happen?
Mellors, if
May
they have
not be
filed-
arising from the same LAC matter, but if in respect of the neighboring land, if they have filed an appeal, will it not have a bearing on that appeal?
That's where, Mellors, when we produced LAC 32, Mellors, they said Exhibit P32, they said it's a different thing altogether. It was also of the same notification. There, the court had awarded, LAC court had awarded 46 rupees. In our case, same notification.
ಯಾವ್ದು ನಿಮ್ದು ಸರ್ವೆ ನಂಬರ್ ಏನು, ಯಾವ ವಿಲೇಜ್?
Namdu, Kamalapur village for me. If they have also filed, if they have challenged award passed in this case, in a way, the answer is yes, Mellors. I have to bow down because both appeals will have to be heard together. If they have not challenged with regard to LAC, this
Where
same
do you find that
LAC.
information?
first page. Kamalapura. 361/3. Survey number. Kamalapura village, Taluku, district, Gulbarga.
ನಿಮ್ದು ಯಾವ್ದಾರು ಇದೆಯನ್ರಿ?
20 cases on a
You
list.
don't know, right now you don't know.
Right now, because it has, just I was sitting, I was hearing some 20, 21 all pending, 20 cases. So it is directly.
But survey number 9/1 and 9/2, it is not a subject matter of any of
Survey
them.
number
All the three appeals which are connected.
361/3.
361/3.
Of Kamalapura village.
Lieutenant Counsel Shri Manavendra Reddy. although not on record for the respondent railways, however submits that he has filed several appeals on behalf of the respondent railways arising from the same notification
Same notification, same village.
and arising from the same village, namely Kamalapura.
Stop.
Full stop. Therefore, learned counsel submits that the appeals filed by the railways should also be heard along with this matter. Full stop. Next para. Both the learned counsels are requested to find out as to which are the appeals.
I will furnish.
Identify as to which are the appeals filed by the respondent railways arising from the same village
Same notification.
and same notification. Full stop. Information as to the appeals filed by the railways, if any, in respect of the same village, shall be furnished in the office, and office is directed to list this appeal along with those appeals filed by the railways. Yes.
Kindly post, fix a date, my lords. Could it be 7th, my lords? We have urgency because
No, no.
2010 ನಮ್ಗೇನು ಊಟಕ್ಕೆ ಇಲ್ದೆ ಆಗ್ಬಿಟ್ಟಿದೆ.
Vacation ಗೆ ನಾವು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಕ್ ಬರಲ್ಲ. Yes.
Final hearing matter, seal number 45, MIL Kulkarni. Seal number 45, final hearing matters, MIL Kulkarni.
Matters called out. There is no representation for either of the parties. List this matter after winter vacation.
Seal number 46, Manvendra Reddy.
Huh? Vacation. ಏನ್ರಿ 2018 ಮ್ಯಾಟ್ರು MFA MBC
Records
ಯಾಕೆ?
after vacation ನನ್ನ ಕಡೆ records ಇಲ್ಲ ಸುಮ್ಮನೆ.
At the request of learned counsel for the respondents, release this matter after winter vacation.
Please.
ಈ ಹಳೆ ಮ್ಯಾಟರ್ಗಳೆಲ್ಲ ಇವು you should not ask for adjournments like this.
Yes.
Seal number 47, Ravindra Reddy.
Senior counsel is appearing. We have taken 2:30.
2:30.
Yeah, Madhyana.
ಆಯ್ತು ಪಾಸು.
Pass.
ಅಷ್ಟೇನಾ? ಪಾಸ್ ಓವರ್ ಏನು ಮಾಡಿಲ್ವಾ? ಕರ್ಬಿಡಿ. ಏನು 2:30 ಅಂತ ಹೇಳಿದ್ರು? ಅದು ಸರಿ.
ಅದು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಮೇಲೆ serial number 37 ಆರ್ಡರ್ ಆಗಿ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಮೇಲೆ
ಡಿಸ್ಪೋಸ್
ಮಾಡ್ತಾರೆ.
ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ, ಯಾವಾಗ ಸಿಗೋದು ಕಾಪಿ?
one state appeal, my lord, tomorrow, my lord. Warrant is issued by the KAT, my lord. Warrant is issued by the KAT, my lord. Appearance of the principal secretary before the KAT, my lord. Lordship have tomorrow, my lord, this matter. State appeal.
All right.
230 matter, my lord, your lordship is,
230.
please.
230.
Seal number 48, Ravi B. Patil, for hearing before framing of
This
charges.
matter, my lord, deputy commissioner is the, on VC, my lord. Today, yesterday's meeting is, my lord, posted today by the chief minister, my lord. That is the reason, my lord, she is not come to the court. But she is appearing, my lord. See, we complied the order of the lordships, my lord.
Complied.
Yes, my lord. Copy is also served to the other side. We issued the conversion order, my lord. In all cases, my lord, except, my lord, that last matter, 50.1, my lord, there is a writ appeal is there. Or that is the reason, my lord. Second.
Yes.
They have complied. 1, 2. Only one matter is left out, my lord. Their appeal is still not.
That appeal has to be
Yes,
dismissed
my lord.
formally.
Please, my lord. Then only,
Thereafter
my
I
lord,
will
yes,
complete.
immediately we'll. Last one.
Barfali.
ಇದರಲ್ಲಿ ವಕ್ಫ್ ಇಲ್ಲ ಸರ್, ಇದರಲ್ಲಿ ವಕ್ಫ್ ಇಲ್ಲ.
But anyway, orders of conversion have been
Yes, yes.
passed in all these matters.
Yes, yes.
Except 50.1.
50 point. ಹೌದು.
Learned government advocate has filed an affidavit of the Deputy Commissioner, Bidar District, along with the copy of conversion order dated 18/12/2024. So, copy of the same is served on the learned counsel for the complainant. So, on going through the conversion order, learned counsel for the complainant submits that the Deputy Commissioner has passed the deemed conversion order which would be in compliance of the directions issued by the learned single judge. Huh?
Please.
Full stop. Next para. We have to notice that in our previous order, we had expressed our anguish that despite directions issued by this court, that we expect the orders of conversion to be passed, the deputy commissioner had not complied with such directions. And therefore, we had directed that the deputy commissioner shall be present before this court on the next date of hearing. Full stop. The deputy commissioner, in the affidavit, has stated that she took charge as the deputy commissioner, Bidar district, recently on 5/7/2024. And due to the rush of work, she was unable to pass the orders of conversion. Full stop. It is also stated that the Honorable Chief Minister had directed many of the officers, including the Deputy Commissioner, Bidar district, to be present at Belgaum.
Please, yes, sir.
For a meeting convened on 18/12/2024 in the matter of Karanja distressed farmers. Full stop. However, the same has been postponed to today, and therefore the Deputy Commissioner is once again required to be present in the meeting convened by the Honorable Chief Minister. Full stop. This is the reason stated in the affidavit for the non-presence of the Deputy Commissioner before this court. Stop. Next para. Having regard to the fact that the orders of conversion have been passed by the Deputy Commissioner in compliance of the directions issued by the learned single judge, we accept the apology tendered by the Deputy Commissioner. Full stop. Next para. The contempt petition is accordingly dropped.
She is on the VC, my lord.
Proceedings are accordingly dropped. The Deputy Commissioner, however, is present through video conference. Yes. So same orders in these three matters.
Yes.
50.1 ನಲ್ಲಿ
in that matter, my lord.
Where that
1.1 ದಲ್ಲಿ, my lord, we produced the, my lord, additional documents, my lord, to show that, my lord, that is a Inam land, but it is not the Waqf land, my lord. It is a Inam land, my lord. In the additional document which I produced, my lord, that is along with IA, in the RTC is also showing the name of the, my lord, Inamdar. That is a slight difference from the other cases.
ಇದೆಲ್ಲ ವಕ್ಫಿಲ್ಲ.
Waqf Inamdar.
ಒಂದೇ ಸೆಟ್ ಹಾಕಿದಾರಂತಲ್ರಿ? Only one set you have filed. Office objection has been raised.
Sorry, my lord, I will comply that, my lord. This is, my lord, you will also pay it immediately after vacation, my lord. Because, my lord, there is a
They
document. to show
comply the
that, my
order
lord.
that become infractions. If they comply the order in contempt,
Ah,
that
Well,
will
that
also
is
become
what-
infractions.
regarding the work,
only
my
the
lord,
end,
that
end
was-
document.
that is, my lord, kindly see along with the additional document, my lord. That is, first document, my lord, extract is produced. That is, Enam grant register. That is serial number 4, my lord. For number 2 issued on 13/3/1983. Anta tolse.
See, it will be the same thing.
Alla,
It will
next-
not make any difference because even in the case of the Waqf board, they are placing reliance on a notification issued.
alla, next, my lord, records of.
Undisputed point of time.
Sorry.
So what we are asking is, on an application filed under section 95 of the Karnataka Land Revenue Act, what is it that the deputy commissioner has to do? Tagiri,
Entry.
95 tagiri. Subsection 2.
Please, if any occupant of.
Odi.
If any occupant of land assessed or held for the purpose of the agriculture other purposes to divert such land or any part thereof to any other purpose, he shall apply for permission to the deputy
Notwithstanding
commissioner.
anything contained in any
Not
law for
saying-
the time being in force.
Any law of the time in force. Apply for permission to the deputy commissioner who may, subject to the provision of this section and the rules made under this act, refuse permission to grant it such a condition is may be effect.
Hmm.
Provided that the deputy commissioner shall not refuse permission
Any
for the.
occupant,
Yes, ma'am.
land
Yes, ma'am.
assessed or held for the purpose of agriculture.
Correct, madam. But
which
yes,
means
yes,
a person whose name is found in the RTC.
yes, ma'am. Yes, ma'am. That is also, I produced that RTC also, ma'am.
Ah.
Last second document, my lord. Even RTC also that name is showing.
Huh?
Second, that is second document, RTC, my lord.
Ida.
Yes, yes,
Ida.
ma'am. Yes.
This is not RTC.
Alla, idu.
Where is the latest RTC, sir?
This is Kasarapani, my lord. This is Kasarapani, my lord. On the basis of this one, my lord, RTC will be issued.
No. The deputy commissioner has to look into the RTC, latest RTC. And if the name of the applicant is found in the RTC, that is the end of the matter.
Correct, my lord. But previous, my lord, Kasarapani,
That whoever claims to be the owner of the property has to raise a dispute in a manner known to law, get the name entered, only then you will get a cause of action to raise an objection. At this point of time, when your name is not found in the RTC, you cannot raise an objection. The same thing would apply, what we said in case of the Waqf board, the same thing will apply to the government also.
yes, that is true, my lord. That is
If the
true.
name of the government is not found in the RTC, the deputy commissioner cannot deny.
Alla, that is true, my lord.
That is all.
because-
Doesn't make any difference whether it is Waqf board or a private individual or the government.
For number 2 is already issued to the Inamdar. And my lord, that is-
ಆಕ್ಯುಪೆನ್ಸಿ ರೈಟ್ಸ್ ಕೊಟ್ಟೈತಲ್ಲ
ಕೊಟ್ಟಿದೆ ಅದೇ.
ಕೊಟ್ಟ ಮೇಲೆ ನಿಮ್ದೇನೈತೆ
ಅಲ್ಲ, for number 2 to the Vinamdar. But these are the, my lord, they are claiming that only on the basis of the RTC and sale deed.
Therefore, if that is true, your name should be entered in the RTC. Aste the same principles would apply. See, we are not denying the fact that a notification was issued by the Waqf board.
Yes, this is not the work.
But
Yes,
the deputy commissioner cannot consider all that on an application filed under section 95 by a person whose name is found in the RTC.
only limited purpose.
Yes. Aste. Same thing.
Please.
Writ appeal,
Yes, last one.
which is that other writ appeal we have dismissed.
But writ appeal number 20019. ಇದು earlier order. ಅದು work ಇದೆ. ಇದು earlier order of litigant and government ಆಯ್ತು appeal.
ಅದೇ
ಇದು ಬೇರೆ.
ಇನ್ನೊಂದು ಸೆಟ್ಟಿಲ್ಲ.
First matter ದಾಗ.
The paragraph number 7 ಅಲ್ಲಿ we have held this.
Yes.
The deputy commissioner in terms of subsection 2 of section 95 of the act is permitted to verify from the documents submitted along with the applications as to whether the occupant of the land assessed or held for the purpose of agriculture is the registered khatedar. Having regard to the fact that the original writ petitioner submitted the record of rights which shows that in terms of mutation order number so and so dated so and so, the name of the original writ petitioner is entered in the record of rights as the owner and occupant of the property in question, then it would not be open for the deputy commissioner to contend that the land in question is a work property. Same principles.
Please.
Learned, you are appearing?
I'm for the Malad.
Responded.
Notice is not ordered, but I
Beam Reddy.
ಹೌದು.
ನಿಮ್ದೇನಾ?
ಹೌದು.
Learned counsel, Ravi B. Patil, who is present in the court, takes notice for the respondent writ petition.
Already directed, he was directed to take notice.
ಆಗಿದೆಯಾ? ನೋಟಿಸ್
ಮಾಡಿದ್ದಾರೆ.
ಆಗಿದೆಯಾ? First paragraph same, huh? Same as in writ appeal number 200193 of 2024. Second paragraph. Learned counsel for the respondent, writ petitioner, submits that under similar circumstances, in an appeal filed by the State of Karnataka, the Deputy Commissioner, Bidar District, and others, in writ appeal number 200193 of 2024, by order dated 11th of November 2024, has held as follows. And paragraph number 7 extract ಮಾಡ್ಕೊಂಡು. Next para, learned counsel would therefore submit that the same principles would apply to the present facts of the case, since the only difference between the said case and this is that instead of the Waqf board claiming rights over the property in question, it is now claimed at the hands of the state government, on the basis of certain documents. What are they? Such as the, such as a copy of the Inam Grant Register.
Kasra Pani.
And Khasra Pani of the year 1962-63. Learned Counsel submits that in the other case too, a claim was thought to be made by the Waqf Board that a notification has been issued declaring that the property in question is a Waqf property, at an undisputed point of time. Full stop. However, this court held that in the latest RTC, if the name of the Waqf Board is not found, no claim can be raised by the Waqf Board regarding the ownership of the property. Full stop. Similar principles would apply in the present case where the name of the government is not found in the RTC and the name of the respondent is found. Full stop. Next para. We accept the submission of the learned counsel for the respondent. Full stop. We therefore proceed to dismiss the appeal in similar terms as was done in writ appeal number 200193 of Full stop. Contemptually, in view of the dismissal of the writ appeal filed at the hands of the respondent state and the deputy commissioner, 2 weeks time is granted to the deputy commissioner, Bidar district to pass orders of conversion as was done in the other cases which were disposed of by an order of even date. Full stop. List this matter on 16th of January 2025.
You lost 3 weeks time may be granted because 3 weeks you lost.
Yenike?
Like, we have to ascertain that one, my lord, then it is a my lord.
In yen ascertain madangilla yenilla.
3 weeks and quarter other.
It is 3 weeks only. Though we have said it is 2 weeks, it is 3 weeks only.
Please.
Yes.
Great.
Yes.
Milliappa error case, my lord, that
Seal number 21, passed out matter.
in that, my lord, I received the instruction, my lord, for this reason, my lord.
Yes, the deputy commissioner can close the VC. Yes. Yes.
Lord, in that matter, my lord, what happened here, petitioner, my lord, was suspended 3 times, my lord, in this case. This is third suspension order.
Warning matter.
Yeah, for this reason, my lord, in that, my lord, against that lady.
We expect similar treatment to be given.
That's true, my lord, but first time, my lord,
Similarly situated employees.
for that is the reason, my lord, we issued the notice, so-called notice, and we are proceeding an inquiry against them also. So far
Why
as
not
that.
suspension?
Because
Why
my-
only this person is placed?
Because my lord,
If they are facing similar charges, we expect you to treat them equally and pass the same orders which are being passed against the other this petition.
this, my lord, in this petition, my lord, in the suspension order, my lord, we clearly stated that, my lord, twice he was suspended, still, my lord, is not ಇದು ಮಾಡಿದ್ರಂತಲ್ಲ ಅದರಲ್ಲಿ ಬರ್ದಿದ್ದೀವಿ ಅದರಲ್ಲಿ. But this lady, my lord, first time, my lord,
It is really unfortunate. Though the tribunal made that observation long ago,
that is,
and you proceed to give charge to that person.
no, that is, my lord, we given to other charge, my lord, that is not given to him. Now, my lord, after the direction of the criminal, my lord, we given the charge to the others.
Where is that lady working now?
She is not working there, my lord. She died. She is working at a deity. Bidar, my lord, that is some other institution, not for this institution.
ಬೀದರ್.
ಹೌದು. Not here, my lord. ಬೇರೆ ನಾವು as per the direction of the KT only we will comply that order.
ಇವ್ರನ್ನ ಬೇರೆ ಕಡೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಬಹುದಾಗಿತ್ತಲ್ಲ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ 3 ಸಲ ಇವ್ರ ಸಸ್ಪೆನ್ಷನ್ ಆದ್ರಿಂದ
ಆಯ್ತು. The procedure or the law should not only be done, but it should also be seemed to be done.
That's true, my lord. Even my lord, contempt is also filed, my lord, against the petitioner, my lord, in so many cases. Your lordship, last 2 days back, my lord, Harshavardhana, my lord, is appeared for the institution. In that case, my lord, because of the, my lord, not considering the recognition, but contempt is filed. Now, my lord, principal secretary is also facing the problem. Because of the deliberately, my lord, is not done, not consider the recognition. 2003-4.
Same allegation is there against that person also.
That is the problem, Lord. For that is the reason we kept under suspension and we are proceeding the inquiry. So far as that lady is concerned, my lord, we transferred to some other place because this first time she, my lord, done this mistake. We are proceeding the inquiry against them. Suppose, my lord, if it is suspension order is, my lord, squashed, my lord, or stayed, my lord.
Can still direct that he may be given posting elsewhere.
That's true. My
I'm
lord.
ready to go. I'm ready to go.
That you will also make observation, because, my lord, he cannot, my lord, sit in the same office and.
No, I'm
that is
ready
your
to.
lordship.
We have been very clearly stating in many of these cases, what is the wisdom behind placing a person under
Yes,
suspension.
that is required. He
We
should
have
not
read
be
the
what-
provision, we have read the judgments of the Supreme
Yes.
Court, and we have stated so.
That observation you will also last, my lord, that we may be permitted to transfer to some other place.
So ಇದಾಗಿ ಇಷ್ಟಾಗಿದೆಯಲ್ಲ.
Annexure D1, page number 137.
On instructions, learned government advocate submits that departmental inquiry is initiated against Srimati Uma Devi Sonnad also, along with the petitioner. Full stop. However, after taking back the additional charge given to Srimati Uma Devi on the petitioner being placed under suspension, Srimati Uma Devi is working at Bidar.
Please.
Yes, and not at the place where the incidents occurred.
Yes.
And therefore, she is not placed under suspension. Full stop. Next para. If that is so, the petitioner also can be transferred to a place. ಎಲ್ಲಿ ಇದಾಗಿರೋದು ಇವೆಲ್ಲ?
ಈ ಸದ್ಯ ಬಿಜಾಪುರದಲ್ಲಿದೆ.
ಅಲ್ಲಲ್ಲ, ಈ ಇನ್ಸಿಡೆಂಟ್ಗಳಾಗಿದ್ದಾವೆ.
ಬಿಜಾಪುರ.
ಏನ್ ಹೇಳಿದೆ? away from Bijapur, where the incidents have occurred. Full stop. This would satisfy the requirement of the law regarding suspension and transfer, as we have noticed in several other cases, that the wisdom behind placing an officer, delinquent officer under suspension is to make sure that he or she will not have access to the records. Full stop. Next para. With liberty being granted to the respondent authorities to transfer and post the petitioner out of Bijapur, we proceed to
Annexure A14. Annexure A14, page 119.
We proceed to allow the writ petition. Stop. The impugned order dated 14/10/2024 at annexure
A14.
A14. Passed by the first respondent is hereby quashed and set aside.
Great.
Full stop.
Consequently, application is allowed.
Huh?
Consequently, application.
Consequently, the impugned order passed by the Karnataka State Administrative Tribunal in application number so and so is also
allowed.
quashed and set aside.
Yes, it is only against the interim order, my lord. While this.
Huh?
Only against the interim order.
Yes, against interim order.
Interim order.
How the
Annexure D. Annexure
prayer
D.
is rejected, my lord. On that ground, my lord is opposed to this.
Annexure D, my lord will find 137, page number.
137, 129. 129. Illa adu haledadu.
137.
137.
Oh.
Order
Last
sheet.
140, my lord, last para, my lord. Under such circumstances, we hold that the applicant has not made out prima facie case.
Impugned order dated 22/11/2024 passed by the Karnataka State Appellate Tribunal Administrative Tribunal in application number 21502 of 2024 is also quashed and set aside.
Great.
Yes. Allare, you filed that application questioning this order, isn't it?
Yes.
Yes, yes.
So now the application also
Yes, yes.
will become
Yes, yes.
infectious.
Yes, yes.
Because we have set aside that
Yes.
order.
This suspension order only challenged.
Application is also allowed.
Consequently, the application filed by the petitioner,
Applicant.
writ petitioner, in application number so and so before the tribunal is also allowed.
Great.
Yes.
Seal number 47, Ravindra Reddy.
Lord, I appear not for the appellant. Matter relates, my lord, to the post of junior station attendant. The main contention of the petitioners, my lord, is that some preference had to be given to apprentices. The learned judge, my lord, has allowed the writ petition and issued certain directions. The lordship should find them. The order begins at page 33. Sorry, my lord, it begins at page 15. And please go, my lord, to page number 31. The notification dated issue so and so, insofar as failing to provide preference for candidates holding national trade certificate and national apprentice certificate for the post of junior station attendant and consequent notification, annexure E, insofar as recruitment to the post of junior station attendant without providing preference to persons holding national trade certificate, apprentice certificate being arbitrary, illegal, liable to be set aside. The condition as to preference for candidates holding national certificate for the post of junior shall be read into the notification. Then last paragraph, your lordship may see. Submitted that recruitment process pursuant to annexure E. My lord, annexure E is issued in 2015. My lord. Is completed and appointment orders have been issued to 1,200 candidates to work an equitable solution. Respondents are directed to appoint petitioners junior station attendants and regularize their service in the existing vacancy or create equal number of posts to accommodate petitioners within 4 months from the date of this order. Practically, the Honorable Single Judge Milord has finished the recruitment process, appointed them and directed us to create a post. That is way beyond what could be granted. But I'll explain, Milord, what the
notification was issued in the year 2014.
Yes, the recruitment notification was in the year 2014 and 15, Milord. Milord, what happened in this case was, Milord, there was an order of the Honorable Supreme Court in an earlier proceeding that some priority and preference must be given to apprentices.
Correct.
Not in here.
That has been extracted in ink page number 40.
Yes,
20.
That,
the last portion of paragraph number 3.
Yes. That judgment itself is also produced.
Road Transport Corporation.
Yes.
Where it was held.
Yes.
That other things being equal.
Yes, Milord. That is a
apprentice should be given preference over direct recruits. And for this, a trainee need not be required to register to get his name sponsored by any employment exchange.
Yes.
Yes.
My lord, your lordships may see, my lord, the order of the Honorable Supreme Court, my lord, which they are referring to is produced at Annexure G, page 82.
Yes.
And you see the operative portion of that order, my lord, which is what is now extracted here. But I'll show your lordships the notification that is issued pursuant thereto. At page 85, my lord. This is what your lordships just now saw is extracted. Para 12, my lord. In the background of what has been noted above, we state that the following would be kept in mind while dealing with claim of trainees to get employment after successful training. Now, kindly note, my lord, what the court was concerned here was, if an employer takes somebody as a trainee or an apprentice, and in that organization a vacancy arises, then what should happen? That was the subject matter of this case. Facts of this case are, none of these petitioners, my lord, that is the respondent before your lordships, none of them underwent training with us. They underwent, they took courses in ITI and others. So now they're saying you must treat that on par with us, and they rely on this judgment. But this is how the lordships will not now give the first direction. Other things being equal, a trained apprentice should be given preference over direct recruits. Then other directions are given. Pursuant to this, we may not issue a notification as Annexure D at page 66. Kindly go to page 81, my lord, sorry. 81. This judgment, my lord, of the Honorable Supreme Court was in 95. The date of the judgment, my lord, is 12th January 95. Now, my lord, as per Annexure F, page 81, we passed this identical things, my lord, what the Honorable Supreme Court had directed. Those apprentice trained candidates in KEB, then my lord, KPTCL had not come into being. Other things being equal, a trained apprentice should be given preference. Now, my lord, these recruitments were all done in 1997. The applications were filed by them in 2015. The challenge, my lord.
So let us see the facts in that case. You are saying that was a case where they were trained in the corporation itself.
Yes, my lord.
Let us see.
Yes, page 82 it begins, my lord.
Yes.
First para, my lord. Para number 2. This prelude is to highlight the idea which we propose to focus as we proceed to bring home the need to make the investment in apprentice trainees useful to society, which would be so when training received by them is put to social use. We are putting this aspect of the matter at the forefront because one of the appellants, namely UP State Corporation, has made grievance about some directions given by the Allahabad High Court to employ those who had received training in the workshop of the corporation. The direction has been given mainly at the call of the promissory estoppel, which is not applicable according to corporation. We would agree with the stand of the corporation, but then another reason advanced for direction is also spending of money on imparting training to the apprentice, which aspect is relevant has already alluded to, and which we propose to buttress further. Before doing so, let the objects behind the enactment of the Apprentices Act and its main provisions along with what has been stated in the apprentice rules be noted. The need for the said act was felt as mentioned in the statement of objects and reasons to ensure the training of apprentices streamlined in the backdrop of increasing demand for skilled craftsmen in the wake of large-scale industrial deployment in the country. The act therefore proposed to provide for the regulation and control of training of apprentices. So, my lord, they deal with the Apprentices Act. None of these persons applied to us as apprentice, nor did they ever work as apprentices. Then, my lord, please go down in the same page.
Do we have that Apprentices Act?
Yes, Apprentices Act alli there. Section 22, my lord, of the Apprentices Act is what would be relevant. I don't know, my lord, if your lordships would have that. But till that book comes, my lord, may I take your lordships through the other point that arises?
I think we have it. We have it here. Section 22 now.
Yes, 22. May I read, my lord?
Yes. Yes.
Sorry, just 1 minute. 22, my lord, reads like this. Offer and acceptance of employment. Every employer shall formulate its own policy for recruiting any apprentice who has completed the period of apprenticeship training in his establishment. Notwithstanding anything in subsection 1, where there is a condition in a contract of apprenticeship that the apprentice shall, after the successful completion of the apprenticeship training, serve the employer shall on such completion be bound to offer suitable employment to the apprentice, and the apprentice shall be bound to serve the employer in that capacity for such period and on such remuneration as may be specified in the contract. Provided that where such period of remuneration is not in the opinion of the apprenticeship advisor reasonable, he may revise this period of remuneration so as to make it reasonable, and the period of remuneration so revised shall be deemed to be period of remuneration agreed to between the apprentice and the employer. So the scheme is that if I go to an employer as an apprentice, then I sign a contract with him. If the contractor says that after your apprenticeship, you have to serve me for a certain period, and I will give you a certain remuneration, that can be given. And that has to be given. And there is some provision for moderation. Now, in the facts of this case, my lord, 2015, the list was announced. And the main grievance, my lord, is this, that if your lordship would, my lord, please turn to in the writ appeal papers at page number 8. My lord, if we, all things being equal is what Honorable Supreme Court said. Now, my lord, these their categories are put here, my lord. These are the names of the respondents. Now, the qualification, my lord, they applied not for assistant lineman. My lord, there's a distinction I want to make. There's some confusion on that. Assistant lineman is the one, my lord, whose qualification is 7th standard. And he is the one who works on repairs and other things on electrical lines which are there. Whereas the post we are now concerned is junior station attendant. The junior station attendant, his role is completely different. He has nothing to do with the handling of electrical lines, climbing the poles, checking the fuses, correcting all those. That's not his job. So this apprenticeship training is something which is important for a lineman, not for a station attendant. So what they've done is they've given 7th standard for assistant lineman, and for junior station attendant it is 10th standard SSLC. And now, my lord, when we receive these applications, we receive thousands of them. We first categorize them in terms of, my lord, their categories first, then their percentage of qualifying marks. Now, please see this table, my lord. This first petitioner, his pass percentage was 36.32. His category was SC. The cutoff for SC was 72.96%. Same way, my lord, for Yatish, he is 3B rural. His marks was 44.64. For 3B rural, the cutoff was 73%. Same way for next person also. 52, whereas cutoff was 73. Next person 46, cutoff is 76. 47, cutoff is
All
73.
these other persons have been given appointment.
Yes. Please
Have
see
been
now
working.
page 151, my lord. I have given the entire list. 151. So junior station attendant.
So from June 2015, they have been working.
Yes. Not the petitioners, my lord, there are others.
Yes, yes. The
Yes.
other.
Yes. And I given, my lord, in this, if a lordships would see, my lord, at serial number 9 is 3B rural at page 151. Here, this is the category to which petitioner number 2 belongs. In his case,
87.68%.
yeah, what the cutoff where we appointed in that category was 81.28, 3B rural, not serial number 9. Whereas this petitioner's marks were 44.
Was there an order of stay?
No, my lord, there's no interim order.
May I make one submission, my lord?
Yes.
My lord, after, my lord, they have taken a decision, my lord, to implement the order of the learned single judge. My lord, there was an, my lord, meeting, my lord, at the chief minister's level, and the board of, my lord, the board has passed in, my lord, a resolution, my lord, to appoint as a one-time measure. And even, my lord, the KPTCL, my lord, even they have resolved, my lord, that they are going to, my lord, meet, my lord, the resources from their own, my lord, funds. And, my lord, now only, my lord, it is at the stage of issuing, my lord, appointment orders. May I pass on, my lord?
I'm not aware, my lord, of this. If my learned friend could please share them, my lord, I'll take instructions. If the government and the corporation decides to employ them, my lord, there is no argument needed. In the normal course, my lord, in the normal course, we'll come to the preference.
There has been some order passed on 7/9/2020.
May I, my lord, point out to the documents, my lord?
It was directed that the matter shall not be precipitated till next date of hearing. However, this benefit may cease unless the direction now given by this court is complied
There is interim order.
within the time prescribed.
Writ appeal alli there is entry mode.
Ah,
Stay,
there is
there is
an
a
ಹೌದು
entry mode.
not to precipitate ಅಂತ.
Lord, Lordship may kindly see the additional documents, my lord, which I have produced.
29/9/2020 is the order.
My lord, this is the page number 2. My lord, this is agenda, my lord, of the KPTCL. My lord, page 3, my lord, with reference to, my lord, the present, my lord, the writ petition, my lord, para 8, my lord, para 8. They made a reference, my lord, with regard to the, my lord, the writ petition in the present matter. And my lord, Lordship may, my lord, kindly come to page 5, my lord, in page 5. Adರಲ್ಲಿ para 16 ಆದ್ಮೇಲೆ, under the circumstances explained above, the subject is placed before the board of directors of KPTCL seeking approval for the following. My lord, it is with regard to, my lord, the present, my lord, response also. My lord, thereafter, my lord, these are the annexures, my lord, and straight away, my lord, Lordship may kindly see, my lord, page 15, which is important, page 15, ink page.
To recruit the apprentice trained candidates of KPTCL training center only.
That's right.
Lord, Lordship may this is, my lord, with regard to the further documents, my lord, makes it clear. Lordship may kindly.
Then it will be contrary to the directions of the Supreme Court also.
Correct.
My lord, thereafter, my lord, page 15, my lord, that's my lord, board of directors, my lord, they have resolved, page 15. My lord, under the board of directors, my lord, by the Honorable Chief Minister, my lord, they have resolved, my lord, at page 19, which is, my lord, the relevant portion, my lord, has been resolved that page 19. Resolved that approval be and is hereby accorded to recruit the apprentice trained candidates of KPTCL training center.
Same thing.
But the
apprentice trained candidates of KPTCL training center only.
Training center and further, my lord, they, my lord,
that will be in compliance of the provisions of the Apprentice Act.
But further, my lord, they take a decision in respect of the present, my lord, respondents also, which is, my lord, again at page ಕಾರ್ಯಸೂಚಿಯಲ್ಲಿ ಹೇಳಿದ್ರು page 22 ಅಲ್ಲಿ 86 ಕಿರಿಯ ಸ್ಟೇಷನ್ ಪರಿಚಯತರು ಹೇಳ್ತಾರೆ. ಅದಾದ್ಮೇಲೆ I will come straight away to, my lord, page 26 and 27. This is the, my lord, the communication of the 26 and 27, the communication of the, my lord, the KPTCL to the government. ಅದರಲ್ಲಿ ಕೆಳಗಡೆ page 27 ಅಲ್ಲಿ ಕೆಳಗಡೆ ಹೇಳ್ತಾರೆ, ನಿಗಮವು ತನ್ನ ಸ್ವಂತ ಸಂಪನ್ಮೂಲಗಳ ಬಳಸಿಕೊಂಡು ಸಿಬ್ಬಂದಿಗಳ ವೇತನ ಭತ್ಯೆ ಹಾಗೂ ಇತರ ದೈನಂದಿನ ಖರ್ಚು ವೆಚ್ಚಗಳನ್ನು ನಿಭಾಯಿಸುತ್ತಿದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಉದ್ದೇಶಿತ ನೇಮಕಾತಿಯಿಂದ ಉಂಟಾಗಬಹುದಾದ ಸುಮಾರು ವಾರ್ಷಿಕ ರೂಪಾಯಿ ಸೋ ಕೋಟಿಗಳಷ್ಟು ಅಧಿಕ ಆರ್ಥಿಕ ಹೊರೆಯನ್ನು ನಿಗಮದ ಸಂಪನ್ಮೂಲಗಳಿಂದಲೇ ಭರಿಸಲಾಗುವುದು ಹಾಗೂ ಸರ್ಕಾರದಿಂದ ಯಾವುದೇ ಅನುದಾನವನ್ನು ಪಡೆಯಲಾಗುವುದಿಲ್ಲ. ಅದರಲ್ಲಿ ಮೇಲೆ 86 ಮಲೋಡ್ ಒಂದು ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ. ಅದರಲ್ಲಿ ದಿ ಪ್ರೆಸೆಂಟ್ ಮಲೋಡ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆರ್ ದೇರ್. ಮೇಲೆ ಕಿರಿಯ ಸ್ಟೇಷನ್ ಪರಿಚಯ 86 ಅಂತ ಹೇಳ್ತಾರೆ. And Lordship may kindly further see, my lord, page 28, King page 28.
ನೇಮಕಾತಿಗೆ ಉದ್ದೇಶಿಸಲಾಗಿರುವ ಹುದ್ದೆಗಳ ಸಂಖ್ಯೆ 86.
86. ಅದರಲ್ಲಿ the present respondents also, my lord.
How?
My lord, that is, my lord, the and as a one-time measure, my lord, they had, my lord, taken this decision, which is.
This is not in regard to respondents, my lord.
It is only in regard to the persons trained in the KPTCL center.
Exactly,
my lord, if I am, my lord, wrong, my lord, let them, my lord, verify, my lord, with their records, my lord, whether, my lord,
even if you are able to point out that they are thinking of doing something like this, it will be contrary to the provisions of the Act and the judgment of the Honorable Supreme Court.
But my lord, the another document, which is in the writ appeal, my lord, 81, which the learned senior councilman had pointed out.
Annexure R6 ಅಲ್ಲಿ post junior station attendant Hyderabad Karnataka post under article 371J ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 67 ಇದೆ. ಅದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಎಷ್ಟು ಇದು ನಂಬರ್ಗಳು ಕಾಣ್ತಾ ಇಲ್ಲ ಸರಿಯಾಗಿ.
The total number your lordships will get at page 153, my lord.
153.
Yeah, 152 in the shuru agutte adu.
ಅಲ್ಲ that is only pertaining to Hyderabad Karnataka posts.
This whole thing is only that area, my lord. This dispute is only regarding that area. These applicants, they are all coming in that area only. So I have produced documents relating to that area only.
To page 153.
The recruitment notification, my lord, 12/6/2015 is at page 73.
Last number is 67.
Yes, that is total number of candidates selected, my lord, in these categories is 67 here.
In your final list
Yes.
of junior station attendants
Yes.
of Hyderabad Karnataka posts, the total number is 67.
Yes, and if you take everything all into consideration, my lord, is 1177. That is, if you take, my lord, all the areas. Annexure E, page 73 is the notification inviting applications. It has various categories, my lord. Kindly see at page 73. 12/6/15. ಥರ್ಡ್ ಲೈನ್ ಮೇಲೆ ಕಿರಿಯ ಸೆಷನ್ ಪರಿಚಾರಕರು ಮತ್ತು ಕಿರಿಯ ಮಾರ್ಗದಾಳು ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಬಯಸುವ ಅಭ್ಯರ್ಥಿಗಳು ಯಾವುದಾದ್ರೂ ಒಂದು ಕಂಪನಿಗೆ ಮಾತ್ರ ಅರ್ಜಿ ಸಲ್ಲಿಸತಕ್ಕದ್ದು. ದೆನ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನೋಡಿ 74. Serial number 3 is Gulbarga Vidyut Sarbaraj Company.
So at page number 192 is the last figure 1177.
Yes. Yes. Total number of persons appointed. So what we are submitting, Lord, is that this seems to be somewhat academic exercise about this preference and all that. Because if we see, Lord, where they stand in the overall merit, they have no chance of coming anywhere near the selected person. So question of, and this Honorable Supreme Court says all things being equal. So, my lord, if there are two candidates who are tying at the same level, then you must give preference to one who has apprentice training in my company, in KEB. But if somebody is some 30-40 marks below in that category, then question of giving them preference may not arise. So the gap is very wide, my lord. All these people are in the 40s. The cutoff is in the 80s. Cutoff for that category only.
Yes, Mr. Mahesh.
My lord, insofar as the, my lord, the notification, my lord, is concerned, they have, my lord, they are not even made in, my lord, the provision in their recruitment notification, my lord. They are not even made in, my lord, provision, my lord, with regard to their, my lord, their earlier, my lord, resolution, my lord, which was pointed out, my lord, by the Learned Senior Council, my lord, which is the Lordship may kindly see, my lord, the notification.
Only 6 of you have filed the writ petition.
Yes, sir.
Huh?
Yes.
Yes. Admittedly, my lord, we have done our, my lord, apprenticeship training, my lord, from the skill department, from the employment and training.
10 years they have not been working now, my lord, with us, 2015.
The Supreme Court has not been considered in the correct perspective.
Was taken into consideration, my lord.
At best, whatever we can do, even if this is true, we will permit them to proceed according to the decision that have already taken.
Please.
That is all. Nothing more. Purple.
But I'm slightly handicapped. I've not seen that, my lord, but I leave it to your lordships, my lord. If my learned friend has filed it.
ಅಲ್ಲೂ ಕೂಡ ಅದೇ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. In both that communication or resolution that he read,
Please.
They have used the word apprentice trained in the KPTCL training center only anta ide.
Please, please.
There. That will be in consonance with the provisions of the Act. And the judgment of the
Honorable Supreme Court judgment. Yes, please.
ಯಾರು ಹಾಕಿದಾರ?
ನಾವು ಹಾಕಿದ್ದೇವೆ. only one
ನಿಮ್ದು?
ground. ಹೌದು.
ಅದೇ ಇದೆ ತಾನೆ.
Same. ಅದರಲ್ಲಿ ಒಂದು without there being a prayer, relief has been granted ಅಂತ. Without there being a prayer, single judge has granted relief ಅಂತ. ಅದೊಂದು ground ಸೇರಿಸ್ಕೊಂಡಿದೆ ಅಷ್ಟೇ.
One additional ground ಹಾಕಿದ್ದೀವಿ. That is at page 32 in the operating portion.
Prayer relief has been granted ಅಂತ.
To create posts and other things, your lordship just now saw at page 32, para 18. The learned single judge notices that recruitments of 1,200 people are over. So the direction is to appoint them.
Are directed to appoint the petitioners.
Yes.
As
And
junior
also create
station attendants and regularize their services in the existing vacancies,
Yeah.
or create equal number of posts to accommodate the petitioners within 4 months. All right.
So none of those were in the prayers anta ಅದಕ್ಕೆ additional ground ಹಾಕಿರೋದು.
My lord, in any of the resolution, my lord, which I have produced, my lord, if they had intended, my lord, to, my lord, select us.
We will leave it at that. We will leave it at that. We will not disturb it. The Karnataka Power Transmission Corporation Limited is before this court aggrieved of the impugned order passed by the learned single judge in WP number 204798-802 of 2015, dated 20th of December 2019. Stop. Next para. The private respondents herein had filed the writ petition aggrieved with the fact that though they were trained apprentice, they were not selected to the post of junior station attendants in terms of the notification. Notifications dated 31/12/2014 and 12/6/2015 issued by the appellant corporation. Full stop. The learned single judge, placing reliance on a judgment of the Honorable Supreme Court in the case of UP State Road Transport Corporation and another versus UP Parivahan Nigam, Shishukshas, Berozgar Sangh, and others. Citation.
Lord, it is reported, my lord,
It is
in
in the-
1995 to
GTT.
SCC, page 1.
Innonsari ಹೇಳಿ
1995, volume 2,
1999.
95, my lord. 1995, volume 2, Supreme Court cases, page 1.
So bracket ಅಲ್ಲಿ 1995 to SCC,
Page 1.
wherein it was held that one open commas, other things being equal, comma, a trained apprentice should be given preference over direct recruits, and for this, comma, a trainee need not be required to register to get his name sponsored by any employment exchange. Stop, close inverted comma. ಇದು in page number 20 ಇದೆ. Next para. Learned senior counsel Shri S.S. Naganand, appearing for the appellant corporation, however, submits, while taking this court through the said judgment of the Honorable Supreme Court, that the judgment of the Honorable Supreme Court was based on Section 22 of the Apprentices Act, 1961. Which reads as follows. Extract Section 22. Subsection 1, 2 ಮತ್ತೆ proviso ಬೇಡ. It is pointed out from the judgment itself that the original writ petitioners therein had received training in the workshop of the UPSRTC, which had issued the notification of recruitment. Full stop. Therefore, having regard to Section 22 of the Apprentices Act, such directions were issued by the Honorable Supreme Court. Full stop. However, in the present case, the original writ petitioners were not trained in the training center of the KPTCL, Appellant Corporation. Full stop. This distinction was not noticed by the learned single judge. Full stop. Next para. Learned counsel for the private respondents, bar writ petitioners, however, has filed a memo today along with certain additional documents. Full stop. Learned counsel points out to some of the decision taken by the appellant corporation subsequent to the directions issued by the learned single judge. Full stop. It is submitted that at the highest level, decision has been taken by the appellant corporation to appoint the petitioners following the provisions of KEB recruitment and promotion regulations, by extending age relaxation in terms of board order dated 13/3/1997, as a one-time measure after completion of ongoing recruitment process for the said posts. Full stop. Next para, learned senior counsel Sri Naganand, however, submits that he does not have the benefit of looking into the additional documents now sought to be produced by the learned counsel for the private respondentship. Full stop. Next para. Having regard to the submissions made by the learned senior counsel and on going through the said judgment in the case of
UP State Road Transport Corporation.
UPSRTC.
Page 82.
Bracket Supra, and having regard to the express provisions contained in section 22 of the Apprentices Act, 1961, this court is of the considered opinion that the directions issued by the learned single judge and the positive directions issued by the learned single judge to appoint the petitioners as junior station attendants and regularize their services in the existing vacancies or to create equal number of posts to accommodate the petitioners, cannot be sustained. Full stop. Nevertheless, if subsequently the appellant corporation has taken a decision to appoint apprentice trained candidates which may or may not include the private respondents herein, the appellant corporation may go ahead and make the appointments accordingly. Full stop. Saka isto?
My lord.
Saku, my lord, only thing is your lordship may say that the court is not issuing any direction, it is leaving it to them, Antast.
No, correct. We have specifically said
Yes, ma'am.
that directions cannot be sustained.
Please, ma'am.
We have said so.
Yes, ma'am.
My lord, if they have taken a decision, my lord, let my lord, the observations not come in the way of appointing us.
Yes.
That if it could be.
Allah, we have not made any such observation that you are entitled to or not entitled. Now, we have simply left it at that if they have already taken a decision to appoint you people, they can go ahead.
Please,
Ashte ಹೇಳ್ರು.
please.
Ordered accordingly.
Yes.
All pending interlocutory applications are accordingly disposed of.